Can you hear me?
Yes.
All right.
No.
Hold on.
Here I can see.
All right, how about now?
Okay, yes, let me see. Let me turn on the volume.
All right. All right, is it going? Can you hear us okay? All right. Sarah, so let me just check the microphones and the cameras.
Okay, yes, I can hear.
All right, so quick question. Stay there. Hold on. All right, we are on. We are live streaming. Let's go ahead and go on the record, please.
You're on the record, sir.
Thanks, sir. All right, we're here in the state of Florida versus Eric Shane Terrell, 18 CT 2900 18 MM 2801. That's counsel, please announce your presence from the state, please.
Michael Single on behalf of the state.
Good morning to you both. And Mr. Gordon?
Good morning on behalf of the defendant.
And for the record, the defendant, Mr. Terrell, is present in the courtroom. Good morning, sir.
Good morning.
All right. I understand this is one last pretrial matter we need to address before we bring the veneer back in. There was an offer, an amended offer that was extended yesterday. Mr. Terrell, I discussed it with you, and I understood that it was your wish to reject it and go to trial today. Is that correct?
That's true.
All right. Let's go ahead and repeat the offer one last time. Make sure that that is the offer that you understood it to be, and it is your choice to reject it and go to trial.
Yes, sir. Thank you, Your Honor. The offer for the charge of DUI was adjudication, $5 fine, 12 months probation, that shall early terminate upon completion of jail, 120 days jail, 12 months driver's license suspension, police evaluation, law registration and testing, alcohol, if an impact can be on 10 pound, 10 day impound vehicle. For cause of
All right, Mr. Terrell, was that the offer that you heard yesterday?
Yes.
And is it still your decision to reject that offer and go to trial today?
Yes.
Very good. All right, thank you, State.
I didn't put the resisting offer.
Oh, I'm sorry. I thought that was everything. Go
And the
ahead.
resisting offer was adjudication, 6 months probation, may terminate upon completion of probation term, substance use evaluation, law registration and testing, no alcohol or cause of alcohol.
Can I say one thing? I just thought that the vehicle comment, they did have it in the email that it was on resist. I don't know if that makes a difference.
Well, does it make any difference to you? Or do you still want to reject the state's offer?
It doesn't make a difference to me. I still want to go to trial.
All right. So the record is clear that an offer has been extended, that the offer was accurately conveyed to Mr. Terrell. Mr. Terrell has exercised his right to reject that offer, maintain his plea of not guilty, and we're going to go to trial. Okay?
Yes, Your Honor.
Very good. All right. Let's bring the veneer in. Everyone check the phone. I'll turn it off. That's fine. I'm going to sit all day. I might as well stand for a moment. Yes, sir, that's fine. I want to try to keep, 6-foot separation as much as possible, so like we talked about, if you just need to get Mr. Gordon's attention, just tap the table, and he'll be able to acknowledge you, okay, sir?
I appreciate it.
All right.
All right, jury. Please stand.
Everyone please rise for the jury.
There it goes.
For rank, everyone's in the right spot? All right, everyone may please be seated. Good morning, everybody. I have to do a little bit better. This may be the only chance to get to talk all day if you end up on this jury. Let's try again. Good morning, everybody. Good morning. Good morning, thank you. My first question is, can you hear me okay? All right, very good. All right, folks, I always start by thanking prospective jurors for being here and fulfilling your civic duty. But I've got to tell you, right now, as a personal matter, it means an awful lot to me. It means an awful lot to the folks who work in this building, to defendants, plaintiffs, prosecutors, to everyone who works here. We owe you an enormous debt of gratitude for showing up today and doing your civic duty. And I want to thank you from the bottom of my heart just for being here in those seats. Jury service is especially challenging right now as we're in the midst of the pandemic. The Chief Justice of the Florida Supreme Court has recognized early on that while you can choose to go to the grocery store or restaurants or anywhere else in society, for the most part, we don't give you a choice if you have to come to court or not. And as such, it's important for us to make this experience as safe as possible when you come. So in order to keep the doors open to our courthouse, we've adapted a number of proceedings and the number of individuals. We've adapted a number of individuals that can come into the courthouse at any one time, depending on the current state of our local COVID numbers. It's important for us to keep operating during the pandemic because we are dealing with various fundamental rights guaranteed under the constitutions of both the United States of America and the state of Florida. Amongst these rights are the right to be advised and understand the charges being brought against you by the state, or the right to confront your accusers. Or, especially as we're doing today, the right to have a trial by a jury of your peers. Or the right to a fundamental due process of law. So it's important for us to stay open, and it's important, vitally important for you, the citizens, to show up and do what you're doing today so our justice system can continue to operate. Any of you who have served on a jury before are going to see things that are a little bit different right now. As you noticed, I'm sure you all noticed, you have these masks on. If you're wondering why they are clear masks, it's because a large part of what we do in the courtroom in a trial setting is try to evaluate what people are saying to us. And let's be honest, facial expressions tell a lot about what somebody's thinking while they're speaking. And so the attorneys have asked for us to figure out a way that they can see your faces while we speak, while maintaining our safety precautions. So I appreciate all of you cooperating and using these devices. It's the best that we have come up with so far to allow us to do this. So everyone will have masks on throughout the course of these proceedings. We will practice social distancing. We have hand sanitizer available to you. and the telescreening to get to the front doors that you all experienced. I am going to ask that all of you keep your masks on at all times inside the courthouse. I'm going to ask that you maintain social distancing from each other while standing, walking, or sitting. And all of us will be doing the same during the trial and during our breaks. I'm going to ask that if at any point you don't feel well, please immediately report it to one of our bailiffs because you may be excused. If this case rolls over to a second day, and you wake up tomorrow morning and don't feel well, please inform the clerk's office immediately, as we will ask you probably not to come back to court. Due to the pandemic, and in an effort to reduce the number of people in the courthouse, we are not allowing the public into the courtroom to observe this trial. And so we had to come up with an alternative means, because one of the most crucial aspects of our justice system is that we do things open and available to the public to observe. Under normal circumstances, any member of the public could walk through that door and just sit and watch what we're doing, but we can't allow that today. So what we've done instead is we've installed these 2 cameras. These cameras are live streaming on YouTube. And so any member of the public can log in at any time and watch what we are doing. You'll notice that both of them are pointed forward right now. Your faces will not be shown on the video. We do value our jurors' privacy, and so we're not going to do that. Once a jury is selected, they'll be seated in these seats right here, and I will rotate the camera, but it'll be in such a way that your faces will not be viewed on the YouTube live stream. Does everyone understand? All right. During the trial, you're going to notice that the attorneys are going to be wiping down the lectern, and we're going to have a porter come and clean the witness box between witnesses. Each of the courtrooms is sanitized nightly, and it's fogged with a sanitizing spray. All of these precautions, while entirely necessary, do unfortunately mean that some transitions and some of the things that we normally do will take us a little bit longer than they normally would. But I appreciate your patience with us while we try to keep this courthouse functioning, but maintain the safety for all those who attend. Now, finally, we are working very hard to help you feel safe while you're here. If you notice anything, if you feel uncomfortable, please let me know. We appreciate feedback. This is going to be, I believe, our 4th jury trial since the start of the pandemic. We're really just trying to figure out these procedures. So any feedback you might have or any concerns you might have are welcome to be shared with us. Now, before we go any further, I'd like to introduce some of the folks who are here in the courtroom. The lady sitting to my left is Natalia. She is our court clerk. It is her responsibility to maintain the records in the court file, handle exhibits entered into evidence, and administer oaths. The gentleman sitting immediately to my left is Corporal Bill Lang. He is our lead bailiff. His responsibility is to keep order and safety in the courtroom and to look after your needs. If you have any questions or any issues whatsoever, you can reach out to Corporal Lang or any of the other bailiffs, and they will bring your concerns to my attention. We also have attorneys present for the state and the defense. Starting with the state, please introduce yourselves.
I was going to go on behalf of Collier County and State Law.
Mariana Freeman, residents of Collier County and State Florida.
Thank you very much. And for the defense?
My name is Sadu Origin, and this is my client.
Thank you, sir. All right. Now, I'm going to tell you, we will take breaks throughout the course of the day. Particularly, we are going to take a lunch break at one point. You may see some of these folks out and about the courthouse. They will not speak to you. If you try to address them, they will avert their eyes and walk the other way. They're not rude. They're going to be following my order. For obvious reasons, it would appear improper for any one of these folks to have any conversations with jurors outside of this courtroom. So I will ask you not to try to speak with any of them because they have been ordered by me not to have any contact with you. Do you all understand? One of the things we're going to be doing today is we're going to have a conversation. We're going to have to ask you some questions, and so will the attorneys. Everything we say is being recorded. There is a record being made of these proceedings. So we have to answer out loud yes or no, whatever the case may be. So does everyone understand? I'm gonna have to ask you to answer a little bit louder. See, we have those microphones up there and we have to be able to hear you. And so I'm gonna press you to please make sure you speak up loud enough that we can hear you. Does everyone understand?
Yes.
Thank you very much, folks. Now, the first step in any trial is jury selection, which is sometimes called voir dire. That's what we're going to do right now. I'm going to ask you some questions to learn a little bit about you. And after I'm finished, the lawyers are going to ask you some questions. They won't be repeating any of my questions, but they may be going into some greater detail. I apologize in advance if some of the things that we ask you feel like we're prying. But it's crucial that we learn about you because we're trying to find folks who can be fair and impartial jurors for this trial. And let me explain what I mean by that. When I say we want fair and impartial jurors for this trial, it doesn't mean you are not generally a fair and impartial person. But if the charge today was battery, and just yesterday you had been the victim of battery, or if you've previously been charged with battery, you may not be the best juror for this trial. Does that make sense? All right. So you may be asked some difficult questions. Some of those questions, the answer that you immediately want to say is, well, I think so. I would hope so. I'm not sure. But the lawyers, and sometimes myself, we're going to push a little bit to get a direct answer, a yes or no answer sometimes. And I don't want you to be offended by that. And let me explain why. Normally, I would ask the question, who here has gotten on a plane recently? But I don't know how many folks can answer yes to that. Has anyone flown, let's say, pre-pandemic? Show of hands. Anyone got on a plane pre-pandemic? Okay. I've got a gentleman in the back right corner, and that is that Mr. Camp? Yes, sir. So, and folks, everyone else who's gotten on a plane before, this will sound familiar to you. So when you get on a plane, traditionally, you walk down the jetway, and it would be unusual to see the pilot standing there greeting everybody as you get on the plane, right? So let's say you were flying to New York, and you said to the pilot, are we going to land in New York safely? And the pilot said, well, I'm going to try. Or, I think so. I hope so. Probably? How would you feel?
I'd be a little concerned.
Yes, sir. I think we all would, right? You might be tempted to turn around and go right back up the jetway. It's the same thing for jurors. The lawyers need to make sure that you, yes, can be fair and impartial. And if the answer to any one of their questions is no, that is fine. That is a perfectly acceptable answer. But we need to know if you can be the right juror for this trial. And that's why sometimes they're going to press, and I'm going to press, for an absolute answer one way to know, because we need to know for sure if you can land the plane safely. Does that make sense?
Yes.
All right. Now, as I indicated earlier, everything is being recorded. So we do need to speak up and indicate yes or no sometimes, as opposed to or because a transcriptionist later on is going to have a very hard time differentiating between the two, but yes and no are distinct. You all understand? Yes, thank you. Similarly, body language is not picked up on the microphones. So if you do that, we have no record of your answer. Does everyone understand?
Yes.
Okay. And for the record, I just shook my head up and down and turned left and right. You will hear the lawyers and sometimes myself do things like that and say things like, for the record, to explain what has physically happened in the courtroom, so there is a record of what just occurred. Does that make sense to everybody? All right. Now, obviously not all of you are going to end up on this jury. And as I indicated earlier, there's all kinds of reasons why you may not be selected for this panel. Please don't take that as any negative reflection upon you. Once again, we're just looking for a panel of jurors who can be fair and impartial for this case. Now, throughout the course of this trial, you may see me doing things on the computer. I promise I'm not looking at how Tom Brady celebrated after the Super Bowl. Everything is computerized now. Statutes are online, case law is online, the case files are online. please do not get distracted if you see me typing something on this computer or looking at my computer. Your focus should be on the lawyers and the witnesses that are being presented before you. Can everyone do that? Yes. Similarly, because I don't always trust computers, you will find me writing things on a notepad, because I've never had a piece of paper suddenly crash on me. If you see me scribbling something down, once again, please don't let that distract you, especially if you are selected on this panel and you are taking notes for yourself. If I'm taking notes, that is not a clue for you to take notes. You decide what's important for you to pay attention to as far as the witnesses and the lawyers. Do you understand? All right. Now, before we go any further, I'm required to read the following instruction. In order to have a fair and lawful trial, there are rules that all jurors must follow. A basic rule is that jurors must decide the case only on the evidence presented in the courtroom. You must not communicate with anyone, including friends and family members, about this case, the people or places involved, and your jury service. You must not disclose your thoughts about this case or ask for advice on how to decide this case. I want to stress that this rule means you must not use electronic devices or cell phones to communicate about this case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any messages to or from anyone about this case or your jury service. In addition, your cell phone or electronic device must be turned completely off while you're in the courtroom. And this is the point where I ask everyone to please check your purses or pockets. Make sure your phone is off. I'm going to do the same. Thank you, everybody. You must not do any research or look up words, names, maps, or anything else that may have anything to do with this case. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, or any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. All of us are depending upon you to follow these rules so that there will be a fair and lawful resolution to this case. Unlike questions that you may be allowed to ask in court, which will be answered in court and in the presence of the judge and the parties, if you investigate, research, or make inquiries on your own outside of the courtroom, the trial judge has no way to ensure they are proper and relevant to the case. The parties likewise have no opportunity to dispute the accuracy of what you find or to provide rebuttal evidence to it. That is contrary to our judicial system, which assures every party the right to ask questions about and rebut the evidence being considered against it and to present argument with respect to that evidence. Non-court inquiries and investigations unfairly and improperly prevent the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. If you become aware of any violation of these instructions or any other instruction I give in this case, you must tell me by giving a note to my bailiff. Now, in the state of Florida, criminal cases are initiated by what's called an information. It's called an information because it informs the defendant in writing what charges are being brought against him or her. These, in this case, are the informations. They've been filed by the Office of the State Attorney, and they charge Eric Shane Terrell, the defendant in this case, with the crimes of DUI and resisting or obstructing an officer without violence. I'll ask you to keep in mind that the information is not evidence and is not to be considered by you as any proof of guilt. It is merely the document that charges the defendant with the allegations that you're going to be presented with today. Does everyone understand? All right. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. This presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Does everyone understand? Whatever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. So, if I were to ask you right now, based upon the charges that I've just read to you, if you had to render a verdict, what must it be right now? Not guilty, because you've not seen or heard any evidence proving the guilt of the defendant, correct? The defendant remains not guilty unless and until the state has proven to you beyond reasonable doubt with the evidence presented in this trial that the defendant is guilty of the charge. Does everyone understand? All right. Is there anyone who feels that they cannot stick with that verdict? Nobody indicated yes. Okay. All right. State, would you please list any witnesses that you may call at this trial?
Your Honor, the state will call Deputy Brian Pissarro of the Collier County Sheriff's Office.
Thanks, sir. All right, many of you know that witness. Yes, sir. Let me get your name, please. Yes, sir, Mr. Greenberg. You know Corporal Pissarro? All right, his brother or friend of yours. So here's a question that you probably, that all of you do at some point or another. Would that relationship affect your ability to weigh the evidence fairly and impartially? Would it at all influence you to render a verdict one way or the other? All right. Can you give both sides a fair shot and determine the evidence based solely on how it's presented to you and the law that I give you in the course of this case? Very good. Oh, yes, ma'am.
Is this wife a police officer also?
I'm sorry?
Sarah is wife a police officer as well?
I don't know the answer to that question.
That would be his sister-in-law.
Okay.
Apparently, he has a sister-in-law who's also a law enforcement officer. I think you know her. All right? I'm going to ask you the same question I asked Mr. Greenberg. And ma'am, your name is?
Tanya Robinson.
All right. Ms. Robinson, how do you know this other deputy who's related to Corporal Pissarro? This other deputy who's related to Corporal Pissarro, how do you know her?
Through the school system.
All right. Is there anything about your relationship with her that would affect your ability to weigh the evidence fairly and impartially today? Will you consider the evidence presented by either or both sides without any prejudice based upon your relationship with this other deputy? Will you be able to follow the law as instructed by me throughout the course of the trial? Thank you, ma'am. All right. Other than Corporal Pissarro, do any of you know any of us personally? All right. No one's raising their hand. Do any of you know each other? Everyone's indicating no. You'd be surprised. Sometimes we have coworkers that end up getting called for jury duty at the same time. Sometimes they get along and sometimes they don't. Do any of you know me personally? No. All right. Please don't take offense. I have to ask the question. Are any of you currently under the influence of any drugs, alcohol, or otherwise lawful prescription medication that would impair your ability to sit as a juror and pay attention today in our courtroom? Everyone indicated no. All right, do any of you have any physical impairments that would make it difficult for you to sit? This is likely going to be a one-day trial. Do you have any physical impairments that would make it difficult for you to sit in one of these chairs and watch a trial today? All right. If any of you do have any accommodations you need us to make for you, please let us know, and we will. Have any of you heard or read anything about this case? All right. The last thing I'd like to discuss before handing the case over to the attorneys is your obligation to follow the law. Now, as you may have noticed, some of what I said to you is somewhat conversational. Some of what I said was clearly read verbatim from instructions. The verbatim instructions that I'm reading to you are standard jury instructions that are promulgated by the Florida Supreme Court. And the Supreme Court says these are the instructions that must be given to jurors in the course of the trial. And so no matter what courtroom you are in, anywhere in the state of Florida, no matter who is sitting up here, you're given the exact same instructions from one courtroom to the next. Does that make sense? It makes sense, obviously, because the law does not change from one courtroom to another. It's not the law according to Judge Brown, it's the law according to the state of Florida, correct? So let's say I disagree with that, and I decide to take these standard instructions and fling them over my shoulder and just start winging it today. How would you all feel about that? Would you all agree that would be a miscarriage of justice? Do you think your role as a juror is any less important than my role as a judge? It is not. And that's the point I want to make. Just as I am not free, under any circumstances, to alter, change, or otherwise determine the law other than what the state of Florida says it is, neither are you. You must follow the law as instructed throughout the course of this trial. Is there anyone here, and that would be important to let me know, is there anyone here who feels you cannot do that? All right. Now, the lawyers have indicated that they will limit their questioning to 45 minutes per side. As we get close, I'm going to give them a time warning. I'm telling you this for two reasons. One, if you see me look at my watch, I'm not bored, I am timing them. And if I give them a 5-minute warning, you'll understand why. All right? Are both sides ready to proceed with voir dire?
Yes, ma'am.
All right, very well. State, please proceed when ready.
Good morning. Thank you all for being here today. I think we're going to see them for glory. I'm sorry,
I can.
Tonight, I'm not raising hands and jump for joy when they need my jury case. I got one in the back. Yes, thank you.
But hold on, I'm sorry to interrupt. Can everyone hear her okay now?
Yeah.
Very good, thank you.
Again, I'm excited to be here. So, again, thank you all for being here. I know that, as the judge explained, we know you guys are very busy. We know you've got other places you need to be, like work or school, or you've got other commitments, or you'd rather be taking a stroll to the park or having brunch with some friends. So we do appreciate you taking your time to show up. As I mentioned before, my name is Marina, and I, along with co-counsel Michael Rosenko, represents the state of Florida. And we are here today to select jurors for this case. As the judges told you, this is a DUI and a resisting an officer without violence case. And so I'm hoping that we can engage in a flowing and open discussion today to allow us to select our jury today. And so we're each going to ask you a few questions. Some may be personal. They're not meant to embarrass you or put you on the spot. If for whatever reason you don't feel comfortable answering the question posed in front of everyone, please do raise your hand and let us know. and we will approach the bench and speak privately with the judge. With that being said, I do want everyone to be honest and feel free to give your opinion. We've all had different life experiences, and so that makes us all different, and that's okay. So if your opinion is different from the person sitting to your right or to your left or in front of you, that's fine. Please don't feel that you can't express your opinion here today. And if anyone is having a hard time hearing me, if at any time I already goes down low, please just raise your hand and let me know. I'm also going to apologize in advance. I may butcher your name, and I do apologize. That happens to me all the time, so it's not fun. But please be correct. And before we proceed, I just want to make sure that everyone has understand everything I've said up to this point and the judge has said up to this point. Has everyone understood?
Yes.
Everyone has heard us?
Yes.
Now, is there anybody here that has something that is so distracting or pressing that's occurring outside of the courtroom that would prevent you from focusing if you are selected for this jury here today? Nope. Nobody raised their hand. Okay. And I know the judge briefly touched on this, but I just want to make sure, is there anybody that has any sort of medical condition or ailment that would prevent them from sitting here, for the next 5-6 hours to hear testimony and evidence? Miss Deanna? And what is that? Okay, so your blood sugar would drop, and is there some way you control from that happening? Okay, you'll eat something if you're home? Okay, and did you bring any snacks that you could, if we needed to take a break, if you're on this room panel, you need to take a break, can you tell the judge, you need to eat or drink something if you feel your blood sugar is going down, would you be able to do that? I'm sorry, I can't hear you.
I didn't bring anything,
Okay,
but I can go to
and get something.
All right. Folks, I'm sorry to interrupt you. You may have noticed there are some salty and sugary snacks provided in the jury room at no cost to the taxpayers. And there's some cookies and some granola bars. There's even a gluten-free option there for anyone who needs it. Will one of those suffice, or do you need us to obtain something for you that you might need, like orange juice and like that? Because we can't accommodate you now. I can't hear you. All right, would one of those snacks work for you, or would you need something else? Those work, all right. If at any point, ma'am, you feel that you need something like that, you let us know, and my bailiffs will retrieve that for you immediately, okay? Thank you, ma'am. State, please continue.
Thank you, Your Honor. Is there anyone else that wants to on hand? And Ms. Tabora? You take a lot of medication too? And did you bring that medication today to take? Okay, and when you say you have to take it later, is that later at night, or is that at lunchtime? Okay, and you said you didn't bring your medications with you? And if you don't take your medication, is that going, what is that going to cause? Okay. So you need to take it in order to be able to stay focused. I'm sorry? Okay. Is there anyone else? No hands? Okay, so let's move on to the elements of the crime that the state will have to prove today. Does everyone understand that the burden is on the state to prove all elements of the crimes beyond a reasonable doubt. Yes. Now, let's talk a little bit about, what are elements. If I tell you, that the law in Florida is that it is illegal to have a pen in a courtroom, what would I have to prove? This method.
You would have to prove that you need that pen in the courtroom.
So I don't have to prove that I have this pen in a courtroom.
So you have to present, in the state of Florida, so basically, no, if there's a statute, no.
So if the statute,
If there's a statute, the Florida statute says that you can have a pen in the courtroom, then, you should have that pen in the courtroom.
okay, so then it's a crime. Would you agree with that?
It's a violation.
Violation of the laws of the law. And so then I would have two things to prove. That I was in a courtroom and I had a pen inside that courtroom. Does everybody understand that?
Yes.
Is there anyone that's confused about that? And I would have to prove both of those elements beyond a reasonable doubt. Not just one, but both of those elements beyond a reasonable doubt. Everyone understand that?
Yes.
Now, Mr. Wilson?
Yes.
Mr. Wilson. If the state presented you with evidence today in testimony that I proved beyond a reasonable doubt that I was holding a pen in a park, has the state met its burden? So if the state presents you with testimony from witnesses or video evidence that I was holding a pen when I was in a park, has the state met its burden? Have I proved my case?
Yes.
If the law was it was illegal to have a pen in a courtroom, that I was in a park,
You have to prove that, yes.
so I would have to prove that I had a pen in a courtroom. But if I was holding this pen and I was in a park, would you say that the state has met its burden? And I proved my case beyond a reasonable doubt?
No,
Why not?
because you have to prove that the pen is actually in the park. Or someone has to be knowledgeable of whatever violations of the law that are given.
So I don't have to prove that the pen was in the courtroom,
Yes,
correct? That's the law violation,
yes,
that the pen is in the courtroom. And if I present you a witness that says, I saw her with a pen, but she was in the park, would you say that the state has proven its case?
no,
And that would be because I'm in a park and not a courtroom,
correct.
correct? And Ms. Lund, would you agree with that?
Yes.
What about you, Ms. Cox? Would you agree that if I present to you a witness that says she was in a park, she's holding a pen, that I haven't met my burden? Now, if the law says that the state only has to prove both of those elements, I had a pen and I was in a courtroom, is there anyone here that would make the state prove more? And what I mean by that is there anyone here that would require the state to prove, let's say, the color of the pen? Would anyone want to know the color of the pen? And would we all agree that we don't need to know the color of the pen because it is not an element that the state has to prove? So therefore the color of the pen is irrelevant. Now, if during trial I present you with two witnesses, and one witness says she was in a courtroom and she was holding that pen, but it was a blue pen. And then the second witness gets on the stand and says she was in a courtroom and she was holding that pen, but it was a red pen. Can we all agree that there's a conflict in the evidence?
Yes.
And what would that conflict be? Ms. Collier?
I didn't hear both of your statements though.
If I presented you two witnesses, and one witness said she was holding that pen in the courtroom, but it was a blue pen, and the other witness says she was holding that pen, but it was a red pen. We all agree that there would be a conflict in the evidence. And what would that conflict be?
Well, it's conflict on the color, but it still is proving that, you have stated the evidence that that is.
Perfect. So we all agree that there can be conflicts in the evidence that's presented during the trial. But if that conflict is not an element that the state needs to prove, it doesn't matter. It's irrelevant. We all agree the state has met its burden. Is there anyone that's confused by that? And that's because the color of the pen is not going to matter. Now, let's go into specific elements of the two charges that the defendant is charged with today. He is charged with resisting an officer without violence and driving under the influence of alcohol. So, the elements of resisting a law enforcement officer without violence are as follows. The defendant resisted, obstructed, or opposed an officer. An officer was engaged in a lawful legal duty. The officer at the time was an authorized law enforcement officer. And the defendant knew that he was an officer. So those are the four elements that the state must prove for resisting. Now, you may ask, what does resisting, obstructing, or opposing mean? And if you're selected for this jury, after the trial, the judge will read to you jury instructions. And you will find that that jury instruction does not have a legal definition for resisting, obstructing, or opposing. So what does that mean? That means that you have to make your own, you have to come up with your own definition. And you do that through your own knowledge, your personal life experiences. That's left up to you. And common sense of what obstruct, resisting, or opposing is. And like I said earlier, we all have different life experiences, so you just have to use your personal experiences. But let's go into a little example, if I can explain that to you. Who here has children? Does anyone have small children, toddlers, teenagers? Yes. Or you know? Or you're shaking your head. How old are your kids?
Sorry,
How old are your kids?
2018,
2 teenagers. And I saw a hand go up over here. Ms. Robinson? And how old are your kids?
17, 18,
And are they boys, girls?
2 boys and 1 girl.
Now, Ms. Robinson, do they always listen to you? Is there times when you ask them to do something and they say no?
Yes.
Now let's talk about when you're trying to put a shoe on a child. Do they always let you put that shoe on? Who said that? Corina? And And Ms. Lilly also said that. Now, Ms. Guarino, do they ever kind of kick your hand back or kick back and refuse to let you even come close to putting that shoe on? They sometimes make you kind of lay back down and let the whole body limp and say, absolutely not, I don't want to put that shoe on. Now, can we all agree that that would be resisting? Now, physically pushing your hand away or kicking your hand away, we all agree that that would be resisting. Now, Ms. Lilly. How many kids do you have? Are they boys or girls? And did you ever ask them to clean the room? And did they say no?
I don't want to say no, but I think this will do.
This can do it. And would you agree that I would be opposing your order? And what if they went and cleaned the room 5 hours later after you told them to? Would you agree that they still opposed your order, even though they eventually did what you told them to do? Somewhat. What if you told them I need you to clean your room in the next 10 minutes? And they cleaned it 5 hours later? Ms. Robinson, would you agree?
Yes.
That you ask your children to do something and they say no, or you ask them to do it within a time frame and it takes them longer, and they eventually do it, that they still oppose your order? Is there anyone that disagrees with that? Now, Mr. Greenberg, what type of duties would you say a law enforcement officer has? And in what way would you say they enforce the law?
Whatever laws there are, just make breaking laws, that they would, stop that.
Miss Ferris? And what, do you have another type of legal duty that you think an officer has? Okay. Maybe instructing, in an intersection, the lights are out, instructing vehicles where to go, making sure that everyone's safe, nobody collides with each other. What about you, Mr. Harper? You think of another legal duty an officer would have?
Sir?
Protecting, sir. And protecting, sir, would you say if they observe them committing a traffic violation, maybe conducting a traffic stop? Would you say if they observe somebody commit a traffic violation, is one of their duties is to conduct a traffic stop? What about responding to emergencies? Does everybody agree that that's a legal duty they may have as well? Does anybody else think of another legal duty an officer has? Now, has anyone here ever gotten a speeding ticket? Yes. And Mr. Harper, you said yes. Was that, positive or negative experience for you? I'm sorry? And do you mind telling us why it was a negative experience for you?
Because I didn't feel like I was going over this either that much. I thought there was some leeway there.
And would that experience affect your ability to judge the testimony of an officer here today who was selected to be on this jury?
No, because that was when I was very young,
Very young.
so I didn't see things like it.
Who else is up to date today? In the back, Mr. Ellsworth?
Yeah.
And Reese?
Sure.
And was that a positive or negative experience with you?
I mean, it was a positive experience for the officer.
I agree, always hurts that wallet when you gotta dish out that money for that speeding ticket. But would you say that the officer was doing his job fairly?
Yeah.
Now, we've got quite a few people here that have law enforcement officers in their family or a relative. Who's your law enforcement? Mr. Wilson, and who in your family or friend or relative is a law enforcement officer?
I have an uncle who's actually chief of police in Fort Myers.
In Fort Myers?
I have several who work for residents who work for LIABILITY, and several who are working for the
And they were talking about their jobs?
No.
No? And would the fact that you have these relationships with those law enforcement officers affect your ability to be fair and impartial here today?
Yes.
And how so?
I mean, everyone has a job to do. They're taking an oath to, represent the law in its entirety. I respect that. And they have a duty to serve our community. So.
Now, with that being said, do you always agree with them?
Not all the time.
So you will disagree with them when you think they're wrong. And the judge will later read an instruction that you are required to follow the law and weigh the credibility of a law enforcement officer, the same as you would any other civilian. Will you be able to follow that law?
Yes.
So if we agree that an officer and a civilian start off at the same playing field, and after you get a testimony, it can either go up or down, if you believe them or not.
My answer is
Yes, so you would start them off at the same playing field. You would not give the law enforcement officer more credibility because of those law enforcement relationships you have in your personal life.
yes.
You would give them more credibility?
No.
Okay. What about you, Ms. Sullivan? So you also have family members in law enforcement? Yeah. Right. And same questions to you, they talk to you about their job? And when you guys are talking about anything, do you always agree with them? And would you also?
I'm sorry, I couldn't hear that last answer. What was that?
I usually give a president here too.
Thank you, ma'am.
And would you would you also, agree to start both, law enforcement officer and civilian witness at the same playing field? If you're selected for this hearing? Ms. Leandra? Do you have any law enforcement members in your family? Who are those? Nothing. Is he here local? And, same question to you, would you treat a law enforcement officer witness, would you take his testimony at a higher, starting point than a civilian witness, or would you start them off with the same playing field? Absolutely. You don't trust law enforcement officers? Okay. And is that because of personal experiences you've had?
Not me, but my son.
Okay. And do you mind telling us a little bit about that?
I was in the pub, it was going 5 miles over the, it was that. He tell the officer, I didn't think I was going to walk, like on 5 miles over the. He said, he's talking to the law. I am the law, I make the law. If I say, if you see 45, you go 45, you go 50, I'm going to.
And so you disagree with the statement the officer made?
I don't believe that is the law. I believe it's the enforcement.
Okay.
But you cannot say it shouldn't say it was the law.
Okay. And because of that statement, you kind of don't trust law enforcement officer? There's other things?
No, other things. But I can go about that. I wasn't to be fair. Okay, I just have to say thank you.
Okay, that's fine. And that's what we definitely want, like I said, we don't want your honesty.
Yeah.
And it's okay if it's different from the person next to you, so thank you very much for being honest about that.
Yeah.
Is there anybody else here? Ms. Cross? Do you have any, feelings about law enforcement? Do you have a family member or a friend?
My father is a retired police officer, and I have a close family friend who's also retired.
And based on those relationships, would you give more credibility to the testimony of the law enforcement officer? No? You would be able to treat their testimony fairly for if you were selected on the juror?
Yes.
And you'd be able to be fair and impartial?
15 minutes.
Miss Lauren, what about you?
My father is a retired police officer
And is that here in Florida?
in New York.
And same questions to you, would you take that relationship with your father and have that, that experience bring it to the courtroom as far as judging the testimony of the law enforcement officer versus the civilian? You would not. You would not have the ability to be fair and impartial? And you would treat the testimony of both the civilian and the law enforcement officer. They start out at the same field, and then it goes up and down based on what they say. And I also saw in your form here that you have a family member that was a victim of a crime. You mind talking to us about that?
28 years ago, my cousin was murdered by 2 of his friends who was 8.
And during that experience, I'm sorry for that. During that experience, was the family members and have good experience with law enforcement?
Yes.
What about with the judicial system?
Yes, they were convicted of the crime.
And would that experience, in any way impact, your ability to be a kind of martial juror here today? Is there anyone else here who, has a negative experience with law enforcement officer that would prevent them from sitting here today if you're selected to be on the jury? All right, now let's, talk about elements of a DUI. It's also the state's burden to prove beyond a reasonable doubt the elements of a DUI. And the state has to prove that the defendant was driving a motor vehicle and that his normal faculties were impaired by alcohol, or he had a blood or breath alcohol level of 0.08 or above. Now, the state can prove impairment either by a breath of 0.08 or above, or impairment of normal faculties, or a combination of both. Does everyone understand that? Now, I will tell you that in this case, there's not going to be a breath. The state is going to be proving DUI beyond a reasonable doubt.
Objection sustained.
So, is there anyone, like I said, if the state can prove impairment, that the normal faculties were impaired by alcohol, is there anyone here that's going to require a breath test? Anyone here that wants to see a breath test? Nobody's shaking their head or raising their hand. Does everybody understand that the state, Mr. Ellsworth?
Is a breath test required by law?
Nope. A breath test is not required by law. As I mentioned, the state can prove it either through a breath test of 0.08 or above, or that the defendant's normal faculties were impaired by alcohol. So the state can prove it either way or a combination of both. And if the state proves impairment through normal faculties, we don't have to prove it through a breath. Is there anyone here that is not okay with that? Everyone's okay with that? Now, let's just quickly give you a hypo. If, let's say you've got a personal trainer and you go to the gym after a week-long vacation, or you have nothing but fried food and junk food. And you get back to the gym and your trainer says, get on that scale. And you refuse. Can he force you to get on that scale? Yes. Joke? What is that? Joke. Do you agree that your personal trainer can't force you to get on to that scale? And would you agree that law enforcement officers cannot force anyone to do a breath test? And you're okay with that? Now, Mr. Lund?
Yes.
Have you ever gone to a bar or restaurant to have dinner?
Yes.
And have you ever seen anyone at the bar that there's a table seated next to you having a couple of alcoholic beverages?
Yes.
And is there anything about their appearance that, after they've had a couple of drinks, is there anything about their appearance that seems a little off to you?
Sometimes they get a little loud, not a little fast, maybe slur their words.
And can you tell if they're impaired?
I'm not for sure, no.
But you just mentioned that sometimes they get loud or their speech is slurred. Maybe their balance is off.
That doesn't mean that I have nothing for sure that they're impaired.
Let me read to you what normal faculties are. Normal faculties include things like walking, talking, being able to see or stand, judge distances, make decisions, act in emergency situations. They're normally perform many, the things we normally perform, mentally or physically, things we perform on our daily lives. Does everybody understand that? Now, if you observe, Mr. Lund, somebody, having a few drinks, being loud, slurred speech, maybe they stumble to the restroom, come back, would you say they're impaired?
I would think that it would appear that they were impaired.
Because you typically would not expect somebody to be slurring their speech or stumbling to the bathroom.
That is correct.
Ms. Ferris, would you agree with that? Mr. Hannigan, would you agree that they're impaired if you observe those things? Mr. Camp,
Yes,
would you agree that they're impaired?
that would be my first impression.
And do you need a breath test to prove that they're impaired?
Why do you drop that?
Yes. If you make all those observations, would you need a breath test to prove that they're impaired?
It seems to me that these are the type of questions that should be discussed during the trial, not before the trial.
Well,
I think that this is setting the stage, if you will, for some predetermination of results. And that's what we're trying to achieve.
well, we're trying to achieve here, Mr. Camp, is to determine if the jurors can tell when someone's impaired. And we've all, a couple of us have already pointed out, Mr. Hannigan, Mr. Lund, that observing somebody at a bar or restaurant having a couple drinks, they see slurred speech, maybe some stumbling, they're loud, maybe some bloodshot, watery eyes, would indicate to them that that individual is impaired. Do you disagree with that?
Sure, there's degrees of impairment.
Yes, there are degrees of impairment, but would you say they're impaired? If you make those observations. Again, because we don't normally expect people to have bloodshot, watery eyes or be loud if they haven't been consuming alcohol. Does everybody agree with that?
Well, there are other ways for people to be impaired, right? There's drugs, there's physical impairments.
Yes, there definitely are.
So,
You can be impaired by drugs or alcohol.
What if they have like a condition or something?
They have a pre-existing condition.
Yeah, I think that was their typical stage. That makes sense.
Okay, it does make sense. Let's say, that pre-existing condition, would you say, odor of alcohol? Would that give them an odor of alcohol? So maybe in that case, we could determine that they weren't impaired by alcohol. If it smells, then you would say yes. Okay. Now something that Mr. Camp brought up, there's different levels of impairment. Would everyone agree that impairment versus drunk is different?
5 minutes, Steve.
That's fine. Would everybody agree that that's different?
Yeah.
And Ms. Mesa, why do you say yes?
Because if I don't see the person trend, I only saw the person acting as impaired, then
I would need, proof that what is he comparing from?
Okay, and if you saw those signs we just discussed, being loud, bloodshot, watery eyes, odor of alcohol, would you then say they're aware?
Alcohol, definitely, it's hard proof.
Okay.
Yes.
And, Ms. Robinson, would you agree that, maybe drunk is at a state where maybe they're falling over, they're vomiting?
Yes.
Ms. Ferris, I see that you wear glasses. So if I take those glasses off of you, would you say, are you blind or is your vision impaired?
I think my lifestyle is basically get around.
Okay, so you would say you're impaired. Your vision is impaired.
Yeah, I mean, I can drive around my.
Okay, so you would not be blind?
No.
Okay. Mr. Parker, you're also wearing glasses. I take those glasses off of you, would you say your vision's impaired? Okay. And so we all make that distinction between being impaired versus drunk. Is there anyone that disagrees? Is there anyone here that would require the state to prove that somebody was drunk? No one? Everybody understands that the state's burden is to prove that they were impaired, that their normal faculties were impaired. Does everybody agree with that? And everybody agrees to follow that law? Now, has anybody here ever been a victim or know somebody's been a victim of a DUI? Mr. Wilson?
Yes.
Okay, and who is that?
Myself.
Your son?
Myself.
Oh, your son. Were you charged with a DUI or were you a victim of a DUI?
I was a victim of DUI. Myself, my family.
And can you talk a little bit about that experience?
It wasn't good. I almost died. Along with, being hospitalized for a month.
So that sounds like it was a very terrible experience for you and your family.
Yeah, very, very terrible.
And being that this is a DUI case, how do you feel about that?
To be honest,
Please.
I have a very, very dislike for the word DUI.
And
Your time has expired. Please conclude your question.
yes, ma'am.
Thank you.
And would that prevent you from, if you selected for this jury, from being fair and impartial?
Yes.
Great. Thank you so much for being here.
Thank you. Defense?
May I approach your honor?
Yes, and counsel, I'll remind you, please go ahead and wipe down the left turn before you. Thank you. Folks, before we do this, you're about to hear some white noise. Normally, I would say, please don't try to read our lips, but you can't. So what I will say is go ahead and stand up for a moment, stretch for just a bit, we'll be right back with you, okay? Thank you. Let me turn this microphone off so nobody on YouTube can listen to what we're saying.
I was just going to ask to see something that's not in place to do with you. Because, like, homeowner association, local lane will sort of to the view of the elderly. Right.
All right, folks. I have a request for a brief comfort break. So what we're going to do is we're going to have you step outside of the courtroom for just a moment. The bailiffs will let you know if you wish to use facilities where they are available to you, and we will reconvene in 10 minutes, okay? All right, everyone please rise for the jury.
Jury, do you hear it? Jury is clear.
All right, everyone completely seated. We are going to go off the record at this time. We will reconvene. It is now 10:52. We'll reconvene at 11:02.
Off the record.
Corporal Lane will say where you need to go. Give me just a moment. Let me turn off the microphones on the cameras. Give me just a moment.
We go back to it, correct?
Yeah, turn the cameras back on. All right. All right. We are back on the record. Mr. Gordon, Mr. Terrell, we are back on the record. Just want to make sure you know. This is State of Florida versus Eric Shane Jarrell, 18 MM 2801 and 18 CT 2900. Counsel for the state and the defense are present in the courtroom. Mr. Terrell is present back in the courtroom. Is everyone ready to proceed and bring the jurors back in?
Yes.
All right, I'll ask for the jurors. Yes, please stand for the jury. Thank you, Mr. Terrell.
None of the three count.
All right, the jury has re-entered the courtroom. Everyone please be seated. Now, folks, before you were brought back in, I was told you had a request to be able to sip a little bit of coffee. That's fine. Particularly in the back of the courtroom, it gets very cold because there are those vents back there. What I would ask, though, if you are going to take a sip of something to drink, remove the mask for just a moment briefly, take your sip, and immediately put it back on. Can you all do that for me, please? All right, thank you very much. All right, so with that, are both sides ready to proceed?
Yes, ma'am.
Ms. Gordon, yes?
Yes, Your Honor.
All right,
Thank you.
please question when ready.
Ladies and gentlemen, I'm going to start with a bit different way. I'm not going to ask the general questions, you have to, I will later on, but we're going to ask, beginning with, this is Nancy, Nessa, is that correct? Correctly? And then I'm going to go down, and then Cynthia Liddy, okay, Cynthia Liddy, correct? So I'm going to go down like this, and then just answer the questions as best you can. So I'm going to ask you a set of 3 questions, and then apply to everyone, and answer to the best of your abilities as you can. Okay? What I'd like to know is, the first question is when you come home or when you're using the television, what's the first television channel that you tune into or you turn on to? Okay? So that's the first question. Second question is, if you have a preference for magazines, okay? What kind of magazines do you read? Okay? Does everybody understand the question? And thirdly, hobbies. What are your hobbies? What do you do in your spare time? Like, to answer those questions in that order, if you can. Everybody understand the format? Thank you. So, go ahead and tell me your, when you come home, what's the first channel you tune into?
I don't turn the TV on.
I'm sorry?
I do not turn the TV on because I have to cook for my family. I come in and I
Good.
do what I need to do.
Okay.
Second is, I read about stocks. So right now, that's what I'm reading.
Okay.
And the third one.
Hobbies?
My hobbies, I like to sew.
Okay. Thank you very much, ma'am.
You're welcome.
Okay. Mr. Jari Milton, please. Go ahead and your. This one's right. Go ahead and tell me your donation habits.
College habits are usually news channels.
Which one?
News outlets, local, NBC, CNN,
Okay.
MSNBC, CNBC.
And then your magazine habits.
Cooking and recipes.
Cooking?
Yes.
Okay. And then your spare time. What do you do in your spare time?
Enjoying family.
Thank you. This is Cynthia Lee. Go ahead on your television habits. What is up for HTTP? Okay, okay. And then magazine. Okay. What about your spare time? What do you do in your spare time? Thank you. Yes, this is Marie Lander. Go ahead and tell me your television habits. What about magazines?
Not much magazine. I do watch sports.
And what about spare time?
Well, I still.
Thank you, ma'am. This is the crop of the state's crop.
I don't have a sheet.
Okay.
Magazines are these like the Olympic and world policy, and like world event stuff,
I'm sorry, what was that again?
like world events.
World events. Okay.
And hobbies include watching sports and reading.
What kind of genre do you read? You got like, what is it, William Shakespeare?
Yep, and like,
Okay.
Scott Fitzgerald,
Okay.
really old stuff.
Thank you. By the way, forgive me because if I'm the distance, spatial distance. Mrs. Donna Collier. Am I pronouncing the last name, Mrs. Collier? Go ahead and tell me your television habits. Okay, magazines.
On back,
And spare time.
reading, swimming,
Reading?
yeah,
What kind of reading do you do?
mostly thrillers.
What?
Thriller,
Thriller?
thriller.
Thriller. I'm sorry. I think the math I gave you, I'm so sorry. And then you said swimming? Thank you. Mr. Harper, am I correct, Mr. William Harper? Go ahead, tell me your television habits.
Sports.
Okay, if the first channel that's what you tune into it, then please say so. If you watch ESPN or something like that. Is that what your favorite channel is, or?
Favorite channel? I just all sorts of sports.
Okay.
Baseball, football, basketball.
Magazine, what do you,
Probably Outside Magazine, Atlantic Magazine.
what's it called?
Kind of like the, cooking magazines.
Cooking?
Cooking,
Okay. What do you do in your spare time?
gardening, walking with my wife.
What? I had a question for you, sir. Do you read, if you were to read a newspaper, what's the first section you would go to?
What issue headlines?
Thank you. Mrs. Susan, Barino? Okay, go ahead and tell me your television habits.
I like home garden channel,
Okay. Magazines?
architectural better.
Okay, and then, your, fair enough.
I like to do meditation and write.
Okay. Thank you very much. Okay, Tanya Robinson, Mrs. Tanya Robinson? What about your television habits, ma'am?
I do the TV guide to see what's on.
TV what?
The guide, to see what's on.
Okay, well, yeah, I mean,
And I like to watch news, news. Pick a magazine, and I like to go to pickleball.
People magazine. You said good news? What about the spare time and hobby?
Boating, pickleball, beach.
Out of those three, which one would you say, pickleball, beach, or?
Boating.
Both your favorite?
Boating.
Oh, boating, I'm sorry. Okay, thank you very much. Mr. Stephen Greenberg, go ahead and tell me your television habits.
Sports channel.
Sports?
Sports.
That's the hunting channel? It is. Go ahead, yeah, go ahead and tell me your magazines.
Florida sports.
Florida Sportsman. By the way, if I'm raising my voice, it's not because of you, but it's trying to make sure that because it's being recorded so it's clear, I know my message is safe and right away. Florida Sportsman. And your hobby, sir.
Fishing and hunting.
Thank you. Mr. Stephen Lund,
Yes.
go ahead and tell me your television habits,
ESPN,
magazines.
Scuba Diving Magazine,
Okay, your spare time.
kayaking and scuba diving.
Thank you very much, sir. This is Devon Im, is that correctly or am I pronouncing?
Devin?
Devin
Yes.
Im?
Yes.
Okay, yes, go ahead and tell me that.
Netflix,
Okay, magazines,
no magazines,
spare time, hobby.
traveling, working out, reading,
Reading, what kind of genre?
life advice,
What?
stocks, life advice.
Okay, let me ask you, a follow-up question. Newspaper, what's the first section of the newspaper you would go to?
Local,
Thank you very much. Is it Christina Ferris? Oh, I'm so sorry. Christina Ferris, I'm sorry.
Anybody, HTTP.
Home garden?
I don't feel any activity and professional book.
Okay.
And then I was exercise.
Same question, follow-up question actually. What's the first section of the newspaper you would go to if you were to go to?
I could probably follow something.
It's this is Senior Tabora. I'm sorry? Entertainment? I'm sorry? You don't read? Okay, and what about your hobby, ma'am? You walk? Now, ma'am, on your questionnaire, I noticed that you said, you did fill out the section, where it was asked whether I can accomplish these tasks in English, read, speak, write, and understand. Can you do all that? Did you understand the English?
Well, I'm not really.
Is English not your primary language?
Right.
The Spanish would be your primary language.
Yes.
And, do you understand all the words that go, do you understand enough to understand what's going on, for example, here today?
No, no.
Okay. Can you read English? Your primary language at home is Spanish.
Right.
So, when a witness is up on the witness stand, it would be a fair assessment that you would understand everything he says. Yes, thank you. Thank you, sir. All right, this is Christina Johe, I'm sorry. Go ahead, tell me how it is. Magazine? I'm sorry? Boat? Okay, and then you spare comment. Thank you very much, man. Stop. I'm sorry. Well, that's your question. Go ahead and tell me if you have something handy. For what?
Wallpaper. Turned on, so there's a noise in the background.
Okay, thank you very much. Okay.
Read magazines, mostly on trade magazines.
What kind of trading, sir?
Building, construction.
Spare time?
Voting. Arts and crafts.
Okay. Thank you. Now it would lead me to Mr. David Ellsworth, am I correct?
Yeah.
Go ahead and tell me your television habits. Okay, magazines? Okay, and then what about your hobbies and spare time? What's that?
I trade stock.
Okay, so. And fishing, right? Same question, what's the first section of a newspaper you would go to?
I wouldn't even know where to buy it.
Mr. Mark Kent? My friend?
That's HGTV, Time Magazine, and Block Beach.
Thank you very much. And last but not least, Mr. Joshua Pappas. Pappas, I'm sorry. But now, if you were to pick up a newspaper, what's the first section you would go to? Okay. Now, the state can ask you some questions during their board diet, and I'm going to follow along. And definition of obstruction, I think she mentioned, and I think I know it was somebody from this side. I don't know if it was Mrs. Cynthia Liddy or Mrs. Clark or Mrs. Sarino. I don't know who was the one who answered. It's like something about a kid obstructing. Did you do that? And I'm sorry, was it you, Mrs. Cynthia Liddy? Okay. Something to the effect of something about kicking and resisting. Does anybody remember what the state was asking? Okay, go ahead, Mrs. Susan Barrio.
She asked me if it was resistance if my child did not let me put his shoes on my
Okay. And something like, I don't know, was you also, was it something opposed? Was it you? Something someone did is an opposed? Okay, let me just go on with your example. Does anybody heard what she said? Okay. You understand, this is a courtroom. The standard that the state is asking, for example, of Mrs. Garino, as far as what resistance is, the instruction doesn't come from the state, it comes from the judge, the court. Do you understand that this is a courtroom? My client's paying court is here today, and this is a legal precedent, and it's not the same as your child resisting you. It's the same standard. Does everybody have an objection to that?
Please approach. Yes, please. One more.
First of all, I think he's confusing the jury members by, first of all, not knowing who said what. I think he's confusing the jury members by, first of all, not knowing who said what. Second of all, the state never said that resistance was like, the child kicking the shoe away, but rather was making an analogy, that was type of resistance. And this is also clearly said that it has no legal definition, that the judge really taught the jury that there's no legal definition for it.
Mr. Gordon?
Yeah, I'm just following up on her statement of what she said. I don't know what the basis for the objection is for who or what, but I'm just following up on her question, and I'm going to follow up on some more questions.
The problem is unclear. There is no standard definition for resisting, obstructing, or opposing. But then you go into it with them and try to define it. So I think it's important to true, you go into how you try to challenge them and explore how they understand it.
And I can tell you right now, I'm sorry.
So the objection is overruled because you, right after you said there is no definition that's going to be given by the court, you never even try to define it. And so, I think the court has to be able to explore that something of the definition of those words further with the bill.
There was no objection to that, Your Honor. What Mr. Gordon is implying by saying that I was making an analogy is that an insignificant analogy is not as serious as the county's report failed, which I think is a problem for the jury.
Well, nonetheless, the objection is overruled. Please continue to go.
I'm going to follow up with a follow-up question. When you ask your child to do something and they oppose that order, I'm going to be saying that's not the same as an order from the police officer.
Okay, I mean, fair enough. I mean, okay, the target's undefined, at least it was asked for some instruction specific to that, so we don't have a specific definition for those words. I think it's fair for the board to go into that listen and make sure, what their understanding of those words are going to be, just like you did.
The court knows. Some of the question that she asked, I would have objected, I didn't object.
You didn't object.
Well, I know. She opened the door and I let it slide. I think I did one objection about the but she did open the door and that's what I'm following up on. Fair enough?
The state explored the jury's understanding of the definition of those words, therefore the defense counsel may do so as well. Let's go.
Your Honor, can I get 2 extra minutes because
2 minutes.
thank you.
Just continue, counsel.
May I proceed?
Yes, please.
This is Green also. So do you understand what I was asking you, that the standard that you get as an order is not the same as what the jury instruction and what this whole proceeding is about, are the same level?
Correct.
My follow-up question was, does anybody have an objection or misunderstanding or don't agree with what she just said? But it's sure raise a hand. I see no, the record, but no one raised their hand. And I think it was you again, Mrs. Garrido, when you ask your children to say something and they oppose that order, do you understand that your order is not the same as a law enforcement order? Does anybody have a misunderstanding of that question that I just had, Mrs. Garrido? Does anybody have a question or issues about that question that I just asked? Does anybody understand what I'm talking about? Yes. With a show of hands, thank you. Okay. And then the follow-up question, something about legal duty. Now, I was asked, I don't know if it was you or I think it was a Reaver, somebody answered saying, officers have legal duty, and that legal duty could include helping traffic when the lights go out. I think I'm sorry, Christina Harris. Okay, yes, ma'am. Was it you that answered that question? Okay. So, and also, I think you said something about emergency response EMS. I'm going to address the responding, the traffic light that goes out. I'm sorry? Correct. Advising people. Okay? Advising people. Follow-up question to that is, when they're directing traffic, are they advising people or helping people, or are they, in your opinion, ordering people? Okay. So, not every direction or every act, the point is, what I'm trying to get, not every act by an officer is a legal order. Does everybody agree to that? Okay. State can prove, I think it was addressed by the state. State can prove their impairment by either way. By either way. Does anybody have, let me just, I'm going to go with Mr. Greenberg. What, do you understand by either way what she was addressing to?
I was saying that, addressing that either the 0.08 for alcohol or food impairment.
Correct. Does everybody understand what he says? The definition of normal faculty. Does you understand? These are instructions that come from the court, from the judge, not from me. When we get into your selection, because we're trying to get the definition of what the jury instructions says, faculties can be impaired, and I think it was Mr. Mark Camp, I don't know if it was you, or somebody else that said it can be impaired by other means. Was it you or somebody else? What do you mean by that?
There are other reasons that people may stumble or people may screw their words. Other than alcohol.
Would you consider driving as a normal faculty?
As a normal.
Yes. Yes, I'm sorry. That's what I was asking you. Would you agree? Okay, would you say that driving is a normal faculty?
No, driving is a skill.
A proficiency?
I'm sorry. Faculty is something in your mind that you're not always does.
Okay. Would it be fair to say it's something that akin to your everyday activities that you don't have to think about as far as doing it?
No, skill is something, gliding is a skill that you learn over time. It's not something that comes to everybody equally and easily.
Okay. Walking, would you say that's a normal faculty?
Sure.
Let me stop you right there. I'm gonna turn to Mrs. Cross, I'm sorry, am I pronouncing, because you said something very interesting. And I don't know if somebody said degrees of impairment, I don't know if it was you, sir. Yes, but you said something very interesting. You said normal faculties can be impaired by something else. Is that a yes or a yes? Oh, by the way, let me explain something. This is, in this courtroom, everything you say is being recorded. In certain other courtrooms, there's a typewriter person, what they call stenographer. So you can't shake your head. You have to say something verbally because the record is being recorded. There's an electronic person typing it out. So that's regularly said. Do you remember what you said about physical handicap? What did you say? Wait. You also said something else. You remember what you said about a certain distinctiveness? Was there somebody else that said something about distinctiveness? Attribute? Okay, that's fine. Let me ask you this. Mrs. Clark, would it be fair to say that certain people may exhibit certain attributes that may be indicative of someone being under the influence, someone being impaired? Does anybody have a disagreement with that? Okay. Nobody said anything for the record. Also, I think the state was trying to make something about impairment versus drunk. The jury instructions go down, the judge says impairment. And I believe what the state was trying to say, drunk. That we don't have to show that the person was drunk. And let me expand on that. I think what the state was trying to say, we don't have to show the person is kissing the curb, is a better line word. Does everybody understand what I'm saying as far as impairment versus drunk? Okay. But more important, if somebody is drunk, would it be fair to say, anybody would disagree, that drunkenness is a high indication of some impairment caused by some external factor, like alcohol, drugs? Impairment, would it be, impairment can be caused by other factors though, just like other, for example, you were saying, handicap. Where we agree with that. Okay, those are all the questions I had for now, I'm going to ask a question. Well, I'm sorry, let me ask you this. It's a very general question. And I think Mr. Bilton, is that correct? He answered this question. He said he would not feel comfortable sitting on a DUI case because he had a bad experience with DUI. Fair to say? True. And you would not be a fair and impartial juror, whether it's for the state or for the defense. Is there anybody here, for whatever reason, for example, let's just say, I'm just making this up, don't want to take it personally. You don't like alcohol. You think I think the 18th Amendment should be reinstated, prohibition of alcohol, for example. Does anybody, for any reason, feel, because this is a DUI case, and for resisting an officer case, I think Mr. Harper was it, that had that experience with a speeding ticket? Yes. All of this later. Does anybody have a reason why they can't sit on this jury because of their experiences with this type of charge crime? Anybody? Yes, ma'am. What would you have a reason for? Either a DUI or your resistance. Your father passed away? Your father was arrested for DUI? And how is that impacting you, ma'am? Let me put it, if you rephrase the question, I'm going to make it very general, I don't want to give personal information, but positive or negative? When I say negative, I should clarify that. For example, it stopped you from drinking, or did it help you get working to be drinking? But, okay, you refrain from alcohol. Okay. And because you refrain from alcohol, do you think you could sit on this jury because it's driving under the influence, it's DUI? Let me rephrase it.
15 minutes left, sir.
You don't know if this is a DUI based on impairment of because of alcohol or drugs, correct? You don't know. But because the charge is a DUI, driving under the influence, I did not specify whether it's alcohol or it's same. Do you feel uncomfortable sitting on a case like this, where it's got driving under the influence to the normal extent of your faculty driving? Do you have confidence in this type of case? You could be fair and impartial. You can hear the deputy get up there and testify, and you would have not a problem. You can follow the judge's instructions. And you could be fair and impartial. Is that you guys think?
Yes.
Thank you. That's right. Anybody else have any issues with a charged crime? Okay, I see no hands. Anybody have a negative or positive experience that would prohibit them from sitting on this type of a case? For the record, I see no show of hands. Let me just get back to you, Mr. Harper. You have a negative experience, but that would not impact your decision as far as listening, making decisions about the fact that in this particular case. You could be fair and impartial. Thank you. Now, one more question before I ask the last question. Anybody, for religious reasons, cannot sit in judgment of others. And just let me, I think I made some notes here. This is Mary Leander?
Yes.
Do you have any issues sitting on this type of case?
I was unhappy with the
I'm sorry?
I feel because I'm unhappy with the officer's state.
So you cannot be fair and impartial?
I think I can be, but it depends.
No, you can't answer it that way. Just remember the judge asked you about the airline question? Can you or can you not? Thank you. Thank you. Let me ask the last question. I'm talking about what I'm going to do. I'm going to start from the very back. John Hobbs. Okay? This is a scenario. Your child, you have a child as a child or a grandchild. He's in kindergarten. You give him a play project. And in that play project, he has to make something. He makes an ashtray. This all. Let's start with Mr. Garfield. When he comes home, tell me what your first reaction. When he comes home and gives you an ashtray. We all know ashtrays are used for smoking. What do you say when the child brings you that ashtray? Oh, I'm so sorry. I'm looking at him. I'm so sorry. I'm sorry. Good job? Thank you. I'm so sorry about that. Mr. Camp, what would you say?
I'll try to find out something else.
Thank you, sir. Mr. Elbert. Encourage making it? I did not see Josh, sorry.
I would refer to the continuing expression case,
Creativity.
Yeah.
I don't want to put words, but you want to have expanded creativity. The star heading. What would you say or do, or what would you say? Thank you. This is Christina Johan? This is Cobora? Thank you. This Christine Paris? Am I correct? Yes.
I just said, I think you need that.
Thank you. This is Devon Gamma?
Why?
Thank you. Mr. Stephen Lund?
I'm Amanda, and make him feel good about what you just done.
Mr. Stephen Greenberg? I'm sorry. Tanya, Mrs. Tanya Robinson?
The bold thing.
No, she is actually, you compliment as a whole.
I said it's.
Susan got it for the, Susan got it on purpose.
I would say that's great. Who helped you make it?
Mr. William Harper? Mrs. Donna Cormier? Stacy Clark?
And that's they knew they needed fostering and why.
And why?
Yeah.
Thank you. This is Marie Lander. Thank you. Mrs. Cynthia Lilly.
I was supposed to know the job that they've done, but when asked if the entire class was the
Ask if the class did the whole thing.
same thing. If everyone in the class made the same thing.
Mr. Dawson?
I would congratulate them on being artistic, so that we have a conversation of why menstruating.
Conversation as well.
Right.
Thank you. Last but not least, Mrs. Nancy.
I would say good job.
Thank you very much, ladies and gentlemen.
Thank you, counsel. All right. Folks, what we're going to do is we're going to take another brief recess. The attorneys and I are going to have a quick discussion, and we'll see you in about 15 minutes, okay? All right, for the jury. All right, everyone please be seated.
You want us to turn around, Your Honor?
Yes, please. All right, before we hold, we're still on the record, and our microphones are still on. So before we go any further, is there anything that needs to be addressed before we go off the record and council has an opportunity to determine the picks?
Yes, Your Honor. I forgot to ask this one, though.
Yes, sir.
Took a break. If you could instruct the jury that you see the defendant or the attorneys in the hallway, they will ignore you, don't take it as an offense.
I did tell them that
Yeah.
at the beginning. Yep, I told them specifically that if I said any of these folks. And so I made it nice and broad, so there's no indication that they won't see anybody out there. Yep. All right, anything else to address before we go off the record? All right, going off the record, we're up to 15 minutes.
Yeah. I told him to stay there.
Are we on the record?
Yes, sir.
Very good. All right, we are back on the record in the state of Florida versus Eric Shane Terrell, 18 MM2801, 18 CT 2900, counsel for the state in defense of the president, Mr. Terrell's present in the courtroom. All right, is everyone ready to proceed with selecting the jury?
Yes, Your Honor.
Yes.
All right. So the way I do it is we start with the first six in the box. So in this case, it's Mesa, Filson, Lily, Leandry, Front, and Cormier. Those are our first six. I'm going to start with the state and see if the state has any motions to strike for cause, and then I'll go with the defense for cause, and then we'll go one at a time with peremptories, back and forth. All right? So out of that, strikes for cause, however, is there anyone on the panel?
Yes, Your Honor.
All right? So state and strikes for cause.
Your state would move to strike juror number 2, Jeremy Bernard Wilson. It's been that he would not be fair and impartial because this is a DUI case.
Defense?
No objection.
No objection? All right. Each person strike for cause. Any others?
Yes, Your Honor. The state could also move to strike juror number 4, Marie Evelyn Leandry.
No objection.
All right. Granted.
The state could also to strike juror number 14.
No objection.
Granted. And sorry, for Ms. Leandry, she did indicate that she did not believe the word law enforcement was speaking the record. And for 14, Ms. Ford did indicate she did not read or speak English very well. It's Spanish was her preferred language. She would have difficulty understanding.
I think she did not understand.
Right. If she had difficulty with English, therefore, it would be a problem for her to deliberate with the other jurors. All right. Any others? From the state? We can find out what they want.
Your Honor, the state would also strike juror number 18, Mark Anthony Camp. He did state when I was discussing normal faculties and what those would be and how he would describe those impaired, he did say that he didn't think it was appropriate as asking those questions, that I was setting up a stage in order for the trial, and I forget his exact words, to sort of sway one way or the other. And that reason the state would to.
Mr. Georgie?
I would object, that's not the basis for a cause challenge. I think she indicated any other reasons for cause that rise up to the level where she cannot be a fair and impartial juror.
Great. Motion strike for cause is denied. All right, any other motions to strike for cause?
Not from the state.
All right, from the defense?
No, nothing.
All right, so starting with peremptory now, the first six in the box are number 1, Mesa, number 3, Lily, number 5, Cross, number 6, Dormier, 1, 2, 3, 4, number 7, Harper, number 8, Gorino. Those are our first 6. State any peremptory strikes of those 6.
Your Honor, the state would strike. Juror number 6, Donna Lee Cormier.
Okay. All right, now to the defense. We're bringing in Tanya Robinson, juror number 9.
Number 6, I'm sorry.
Yes, sir. I've got our 6 now are Mesa, Lily, Crotts, Harper, Areno, and Robinson. 2, 3, 4, 5, 6.
I always strike Mrs. Robinson.
All right. To the state, we've got Mesa, Lily, Cross, Harper, Gorino, and Greenberg. 1, 2, 3, 4, 5, 6.
Your Honor, the state, is okay with that now.
State accepts. All right, defense, you have 2 peremptories left. The panel is Mesa, Lilly, Cross, Harper, Garino, and Greenberg. Jurors number 1, 3, 5, 7, 8, and 10.
Don't go ahead and do what you feel like is necessary, because I can't remember the 2 lines. I'm leaving. Go ahead.
Your Honor, we would like to strike Mr. Greenberg.
All right. Panel is now number 1, Mesa, number 3, Lilly, number 5, Cross, number 7, Harper, number 8, Garino, number 11, Lund, 1, 2, 3, 4, 5, 6. To the state, you have 1 peremptory, I'm sorry, you have 2 peremptories left.
The state's okay with that now, Your Honor.
State accepts. To the defense, number 1, Mesa, number 3, Lilly, number 5, Cross, number 7, Harper, number 8, Garino, number 11, Lund. Sure.
So we're on to, Mr. Stephen Lund, correct, Mr. number 11?
Yes, sir.
Just very concerned.
Go ahead.
I want to make sure with my client that these are the jurors that we would like to have. That's fine, Your Honor. We are accepting this jury as it is.
All right, so let me confirm with both sides. Number 1, Mesa, number 3, Lilly, number 5, Cross, number 7, Harper, number 8, Garino, number 11, Lund. 1, 2, 3, 4, 5, 6. Both sides accept. Serving the state.
Yes, Your Honor.
Defense.
Yes.
All right, very good. We've got a jury. Now, we had talked about alternates. We look to be very much on track to have a 1-day trial. Does everyone agree?
Yes, Your Honor.
Mr. Gordon?
Yes, Your Honor.
You agree we're going to have a 1-day trial? It really looks, we've got 1 witness and possibly the defendant if he chooses to testify, and that's it, correct? All right. So we want 1 or 2 alternates. I'm comfortable with 1.
1 is fine.
1 is fine, Your Honor.
Very good. So that gives us Devin in state.
Can we strike that alternate, Your Honor?
Yes, ma'am. All right. That gives us Christine Ferris as our alternate to the defense.
Yeah, we would like to start Mrs. Christine Taylor. Yes, I would like to start Christine Taylor.
All right. That gives us, is it pronounced Jokic? Jokic. I'm pretty sure that's how she said it, yes? All right. Number 15 is our alternate. Steve, does that work?
Yes, Your Honor.
Yes, Your Honor, that works.
All right. So we've got our jury. Let's just confirm one last time before we bring them in. Nancy Mesa, number 1, Cynthia Lilly, number 3, Stacy Crotts, number 5, William Harper, number 7, Susan Garino, number 8, Stephen Lund, number 11. Those are our 6. Our alternate is number 15, Christina Jokic. Agreed?
Yes.
All right, so before we bring them in, it's 12:20. I would be inclined to go ahead and give everyone a lunch break at this time, and we can start with openings once we get everyone back in. Does that work for everybody?
Yes.
Yes, Your Honor.
All right, what I'll do is I'll ask everyone to return at about 1:30. As the jurors get back here at about 1:30, State, I'll ask that everyone, you all get cut of here a couple minutes early, get the monitor ready to go. There'll be bells in the courtroom so that you'll be able to get in. But let's get ready. Have jury instructions been delivered to the defense?
Yes, they were, but, would you like us to go over before jury comes?
We don't have to have a full charge conference. Are there any particular issues you wanted to address so we can be adjusted during lunchtime?
I'd rather come here, I will talk to her,
Okay.
I'll be here like around 20 minutes before.
All right, if the attorneys are all back at 1:15, is that enough time of a break for everybody, or have the attorneys back at 1:30 and have the jurors be
I'll be
here?
here at 12. I'm just gonna grab.
Your Honor, if we can have us return at 1:30, and then the jurors,
All right,
2 minutes later.
So 1:45 with the jury?
Or,
Well,
I don't think.
I'll tell the jurors to be here at 1:30. We might bring them in at about 1:45 once we settle everything, but, try to get here a couple minutes early.
Correct.
Yes.
Let's make sure the monitor is ready to go. Let's have the lawyers discuss any issues with the jury instructions so we can have a quick charge conference. Anything else we need to address before we bring the panel back in?
No.
Your Honor.
No. I was gonna ask to see if the bill is having ready like around 1 o'clock.
He's not going anywhere, so as soon as you want, we can have him in there.
Thank you.
All right, I'll ask the jury.
Go ahead, bring the jury in.
Don't let anybody go. That we want to see them.
Okay.
Don't send anybody home to start on the go upstairs. All right, the jury has re-entered the courtroom. Everyone, please be seated. All right. Folks, I've got good news. We have selected a jury. When you hear your name called, please rise. All right. I've got Nancy Mesa, Cynthia Lilly, Stacy Crotts, William Harper, Susan Garino, Stephen Lund, and Christina Jokic. Did I pronounce that correct? All right. All right. Do both sides agree that this is the jury that has been selected?
Yes.
All right. Madam Clerk, please administer the oath. Folks, please raise your right hand.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence?
All right, everyone indicate yes, please be seated. For everyone else, your time and service has come to a conclusion as a juror. I truly do want to thank you from the bottom of my heart for being here. We function in this courthouse and in this courtroom based upon the bedrock of jury service. Your very presence here allows us to keep the justice system moving. And I truly do thank you on behalf of myself, the courthouse personnel, the attorneys, and the citizens of the 20th Circuit. Thank you. Have a wonderful day. All rise for the jury. Everyone who was selected as a juror, please remain. Please be seated. Now, the folks who have been selected as jurors, I think, are we going to give them the new pins so they can be identified? Is that right? Or are they just going to keep the stickers? We give them the actual pins, or we do the stickers?
I can get them ready.
I think the pins are following stickers.
Usually we use them for
That's fine. That's fine. All right, folks, we're going to take a lunch break at this time. All right, it's 12:25. I'll ask you to be back here at 1:30. The lawyers and I are going to convene a little bit earlier so we can make sure we take care of as many pretrial or other issues as possible, so we can get right back in here. We're going to go into opening statements and the presentation of evidence. So you are free to go about your business. You're free to use your phones in the meantime. Do not talk about the case with anybody. If you have any concerns or issues during the break, please bring it to the bailiff's attention. But otherwise, have a wonderful lunch, and we'll see you back here at 1:30. Corporal Ring, you'll let them know where they need to assemble? Thank you. All right, Peter. Folks, see you back here at 1:30. All right, anything else for us before we take a break? All right, I'll see you back here at 1:30. Going off the record.
Yeah.
Pretty much.
Yeah, on the record, sir.
There we go. All right. I should still be live streaming. Let me just make sure.
Yes. Yeah, but thank you. They're all very members of that.
You're all here?
Yes.
There we go. Mhm. Okay. All right, we are back on the record. Once again, it's the state of Florida versus Eric Shane Terrell, 18MM2801 and 18CT2900. Counsel for the state and defense was present. And defendant Mr. Terrell is back in the courtroom. All right, we do have a jury selected and sworn. So when we bring them in, I'm going to read 2.1. I'm going to read 2.1A, the note-taking instruction, and we'll go into opening statement. State your witnesses present.
Yes.
You don't have to get him. I just want to make sure he's here and ready to be called.
Yeah, he was up on, let me just,
We've advised him to sit inside this room right here, so you
Yes, sir.
have instructed him to do so also.
he was here.
Okay, so he is here and available to be called when ready for him.
Yes, Your Honor. Let me, can I have 1 second?
Can you put the officer in the sidebar?
Yes, he is outside.
Okay,
Ready to go.
I was gonna invoke the rule, I think that's a new one.
there's one witness. Yeah. All right. The AV equipment has been prepped and ready to go.
Prepped and ready to go, Your Honor.
Very good. All right. Were there any issues with the jury instructions that you want to address now, so one of the other members of the state attorney's office can make adjustments while we proceed with our trial and allow the charge conference to go a little more smoothly?
Your Honor, I have a copy of the jury instructions for you. I also gave a copy to Mr. Gordon.
Very good. Mr. Gorgon, do you have any significant issues you'd like to address now that can be fixed while we're
No, you're
trying
not
to
going through right now.
Your hair looks fine.
Thank you, sir.
So, Mr. Terrell, go ahead, Mr. Gordon. I'm just going to go over the procedure going forward with Mr. Terrell. Here's how the trial is going to go. Okay, sir. I will give a brief instruction to the jury. State will go ahead and give their opening remarks, and then your attorney has the option of giving opening remarks as well. State's going to call their witness. They get to question first. Your attorney will then get to cross-examine that witness. Okay. If the state produces no other witnesses or evidence, they will close their case. We will likely have a brief discussion about the state's case, and then it'll be the defense's opportunity to present a case if you wish. So one of the things I want you to be thinking about, and we'll have a more in-depth discussion in a little while about it, is whether or not you wish to testify. Don't answer my question now. We will get to that, but that's one of the questions you're going to want to have ready to be answered when we come around to that point, because I am going to ask you if you're going to testify on your own behalf or not. It's your right to testify. It is also your right to remain silent, and I will specifically instruct the jurors that they cannot hold that against you in any way, shape, or form, because the state has the burden of proving their case against you. You don't have to prove or disprove anything. You understand?
Understood.
All right. Once the defense's case is closed, I'm going to instruct the jury on the law. We'll be closing arguments. The state gets to go first and last. Your attorney gets to do a middle argument, and then they will deliberate. You understand?
Yes.
All right. All right. Is there anything we need to address before we bring the jurors in? All right. Let me do this. I'm going to turn off this camera. While we walk the jurors in this camera, while we walk the jurors in, I'll turn it back on once they're seated. So that way they're not being paraded right in front of the camera. All right. Is everybody ready?
Yes.
All right, phone check. Let's bring in the jury.
Aaron, you can bring the jury. You want to shut off that one too, or no?
No, no, because they'll pass they'll pass with some of it like that.
Okay. Ready, Judge?
Yes, sir.
You're out of the jury. There's one more slide.
John, what we're going to do, we were going to have 4, yeah, there we go. Perfect. And this should allow for appropriate social distancing for everybody, okay? All right, the jury has entered the courtroom. Everyone please be seated. Ladies and gentlemen of the jury, you've been selected and sworn as the jury to try the case of the state of Florida versus Eric Shane Terrell. This is a criminal case. Eric Shane Terrell is charged with the offenses of DUI and resisting, obstructing, or opposing an officer without violence. The definitions of DUI and resisting an officer without violence will be explained to you later. The state's charging document, which is called an information and was shown to you earlier, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Eric Shane Terrell in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you're not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They'll be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, the alternate juror will be released, and you'll then be permitted to retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, please notify court personnel of the violations. During the course of the trial, the court may take recesses, and you'll be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just talk about this case face to face, you must not talk about this case using an electronic device. You must not use phones or computers or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys at every hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they'll be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. Now, if you would like to take notes during the trial, you may do so, and each of you have been handed a notepad and a pencil. On the other hand, of course, you're not required to take notes if you do not want to. That will be left up to you individually. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you've completed your deliberations, the bailiff will deliver your notes to me. I will personally shred them. No one will ever read your notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should only be used as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Now with that, if you might be taking notes, I'll ask that you do the following. On the front page of your notepad, just put your name. All right, that's going to be your cover sheet, and also identify which notepad is yours. If you choose to take notes, flip to the second page and begin your notes there. So when we take breaks, you can put that cover page down and no one can read your notes, okay? All right. Any objections to the instructions as given thus far?
No.
All right, are both sides ready to proceed?
Oh, yes, you are.
All right, State, please proceed with your opening statement.
Please report, counsel, members of the jury. 3 minutes. 3 whole minutes is how long it took for the defendant to pull over when Deputy DeSaro of the Collier County Sheriff's Office attempted to conduct a traffic stop. Deputy DeSaro is going to take the stand today and tell you that at 3 a.m. on Friday, December 7th, 2018, he observed a red SUV make a U-turn on Golden Gate Parkway near Collier Boulevard. He is going to tell you that this red SUV caught his attention because it made a wide turn, drove up and onto the curb, and then sped away quickly onto Collier Boulevard heading south. Deputy DeSaro is going to tell you that based on this erratic driving pattern he observed, he decided to follow this SUV because he believed that the driver might be impaired. The evidence the state presents today will prove that the defendant was the driver of that red SUV. Deputy DeSaro is also going to testify that he used his overhead emergency lights to indicate to the defendant to pull over. He's also going to tell you that he had to use his sirens. He had to use his spotlight
and he even used his PA system to verbally order the defendant to stop the SUV. And the defendant ignored it all. Members of the jury, the state will present video evidence that shows that after the defendant finally pulled over, he had to be physically removed from the vehicle because he continued not to follow orders. The evidence is also going to show that Deputy DeSaro observed that the defendant had bloodshot, watery eyes. He smelled an odor of alcohol coming from the defendant. The defendant was repetitive and kept interrupting the Deputy DeSaro's investigation. Based on Deputy DeSaro's observations and his training and experience as a law enforcement officer, he arrested the defendant for DUI and resisting an officer without violence. Deputy DeSaro is also going to testify that he read implied consent to the defendant. That the defendant understood that he would lose his license for 1 year if he refused to provide a drug test. And the defendant refused. He said, "There is no reason for me to do that." At the end of this trial, the state will prove beyond a reasonable doubt that the defendant was driving a motor vehicle and he was under the influence of alcohol to that extent that his normal faculties were impaired. And the state's also going to prove that the defendant resisted and opposed a law enforcement officer. And we will ask you to return a guilty verdict as to both charges. Thank you.
Thank you. Defense, are you prepared to offer an opening statement at this time?
Oh, yes, Your Honor, yes, I do.
Very well.
Good afternoon, ladies and gentlemen. What the state said in their opening statement, for the most part, is absolutely correct. And the state makes a very interesting comment. One of the comments that in their statement, the statement that she said was, there was no reason to give a breath test. We're going to hear testimony from the detective. You're going to watch a video. This statement that she just stated, the prosecutor just stated, is very important. Now, furthermore, in the early mornings of December 7th, there is no issue that my client was driving. There's no issue that there was a U-turn, that whether it was wide or not, that's be up to interpretation. There's also an issue of erratic driving pattern. It's our position, defense's position, that the video is not going to show any erratic driving. And also, I think the state mentioned something to the effect that physically removed. The video will show that my client was not physically removed from the vehicle. He opened the door, he got out. Now, the evidence that's going to be presented by the state is you have to evaluate based on your personal knowledge and your experiences. But here's the facts. The state has charged my client with two charges. One is, as she said, driving under the influence of alcohol. Their statement is on or about December 7th. This is the information, what they call the charging document. In civil court, it's called a complaint. In criminal court, it's either called an indictment or an information. In this case, it's an information. It says on or about December 7th, 2018, in Collier County, Collier County, Florida, did unlawfully drive or was in actual physical control of a vehicle within this state while under the influence of alcoholic beverages, any chemical substance set forth in subchapter 877, or any substance control under chapter 893. When affected to the extent that his normal faculties were impaired, or, semicolon, or with a blood or alcohol level of 0.08 or above. They have to prove all these elements to you beyond a reasonable doubt. It's our position that the state's not going to meet that burden. Furthermore, He's been charged with resisting an officer without violence. Their charging documents for their complaint, in essence, says, on or about December 7th, 2018, in Collier County, Florida, did unlawfully resist, obstruct, or oppose Deputy Brian DeCero of the Collier County Sheriff's Office in the execution or legal process in the lawful execution of a legal duty, to wit, this is the important part, conducting a lawful traffic stop contrary to Florida statute. It's our position that after hearing all the evidence, that the state is not going to meet the burden, especially when it comes to conducting a lawful traffic stop. So, without further ado, I'll let the state proceed. Do you want me to play this?
Yes, please. Before when he's done, we'll readjust.
Yes, sir.
State, please call your first witness.
Thank you, Your Honor. The state would like to call Deputy Brian DeCero.
Okay.
Step up here, sir. Raise your right hand and face the clerk.
Do you solemnly swear or affirm that testimony you shall give shall be the truth, whole truth, and nothing but the truth?
Yes, I do.
Have a seat in that chair, sir. Watch your step.
Good afternoon, sir.
Good afternoon.
State, whenever you're ready.
Thank you, Your Honor. Good afternoon, Deputy. Thank you for being here. Can you please state your name and spell your last name for the record?
Yes. Name is Brian, last name DeCero, D-I-S-A-R-R.
Sir, what is your occupation?
I'm a deputy sheriff for Collier County Sheriff's Office.
How long have you been employed with the Collier County Sheriff's Office?
8 years.
During those 8 years, have you been assigned to the same duties the entire time?
No, I have been assigned to the communications department and the patrol division.
How long have you been assigned to the patrol division?
Approximately 4 years.
And what type of training did you receive to become a law enforcement officer?
We do extensive academy work, which is 770 hours. We also have the in-service training throughout the Collier County Sheriff's Office, which is primarily high liability, driving, defensive tactics, DUI training.
Were you on duty the evening of December 7th, 2018?
Yes, I was.
And what task were you assigned to that night?
I was part of our night patrol division in Golden Gate City.
And what does the road patrol entail?
We encompass a multitude of tasks: domestic violence calls for service, suspicious incidents, traffic stops, or traffic duty.
Were you in a Collier County Sheriff's Office marked vehicle while you were on that shift?
Yes, that's correct.
Were you in your Collier County Sheriff's Office uniform?
Yes, that's correct.
What time of day was it when you first observed the defendant?
It was approximately 3 a.m.
What type of vehicle was the defendant driving?
It was a red Dodge, Durango SUV.
Would a visual aid help your testimony today in identifying where you first saw the defendant?
Yes.
Your Honor, I'm gonna object to this. May we approach?
Yes.
Hold on. Hold on.
We will have to start. We'll hold, I would say the jury security is there. So he took the last of my law, I say the jury security, so I wanted to call turn it down to the. Okay. First and foremost, the evidence presented with all the intimidation that he's showing to the jury. It should be covered. Secondly, I've never been told whether it's I was never given notice to discover exactly whether it's a map or a certified map.
We're not considering anything for evidence, it's purely to aid the officer in his testimony, and it was also placed in the back of him as a vehicle before.
I would object, it's not been disclosed as part of any disclosure. I'm not saying it has to be entered into evidence in order to be disclosed. I understand it's a demonstrative evidence, but it's never been demonstrative.
It's a right now, it's just a demonstrative. Are you planning on having him mark this map or anything like that?
I was planning on having him point out where he got the defendant on the map, and I was going to have him mark a few spots on the map with a fit of blue. I mean, map, so the court could see some distance where the event took place.
I completely understand what this is going to do. This has to be disclosed as a part of normal customary discovery procedure.
We're gonna have to excuse the jury.
Folks, as you recall, hold on, folks. Please turn it that way. Thank you. All right. As I indicated earlier, there are going to be moments where I need to have a more in-depth conversation with the attorneys that rather than us trying to speak loud enough that we can hear each other over the white noise, but quiet enough that you can't hear us. It's just going to be easier if we excuse you for just a moment. So I'll rise for the jury. We'll be back with you in just a bit.
Please leave your notes where you're sitting, take all your belongings, and follow the deputy out the door.
Hold on.
Clear?
After we're done, may I have a word with him in the back room? Because he's making some verbal gestures that I don't think is appropriate.
I'll give you a moment to talk to your client. Everyone, please be seated. All right. So, in case the white noise otherwise interfered with our ability to address this matter, let's review the issue for the record. The defense is raising a discovery objection, alleging that there is a discovery violation because this map that the state wishes to present before the jury was not disclosed. The state has presented the position that it did not need to be disclosed because it was intended to be used as a demonstrative aid. Now, that being said, the state intends to have the witness mark it, essentially showing the path of the pursuit in this case, which for all intents and purposes is effectively turning it into a piece of evidence before the jury. It's not really demonstrating what he's doing. He's testifying and then showing the jury his path. That is, for all intents and purposes, turning it into an item of evidence. And since it has not been disclosed to the defense, I believe a retrospective inquiry is appropriate at this time. It is the safest course of action for the court to take since the discovery violation is being alleged. So, let's do that. Give me just a moment. While I'm looking this up real quick, Mr. Gorgon, would you like to inspect the state's exhibit at this time?
I know, yes, I would.
Now look at what you This is an overview. Where the following was, where the traffic stop took place. And this is a closer look. So the traffic stop occurred. These are
Yes, I'll be reviewed, Your Honor.
All right.
I'm gonna discuss it.
All right. So the first, obviously the first question is, were the exhibits ever disclosed prior to today?
Your Honor, it's permissible because it's not new information.
I'm conducting a Richardson inquiry. Answer my question, please. Were the exhibits disclosed prior to today?
Were those maps disclosed prior to today? No.
Okay.
I concur.
They were maps out of the information that's in the report.
All right. So then the question is, in just a moment.
Sure.
Mr. Gorgon, how would, had it been properly disclosed, how would it have affected your preparations for trial?
Your Honor, I think what they're trying to do, it would affect it, would it be prejudicial? Yes, because it's trying to show the length. And I would have prepared my client's defenses differently as far as if those were disclosed. If that's your answer, if that's what you want to answer.
My question is, how would it have materially affected your preparations for trial? What about those maps would have changed your preparation for trial?
Let me ask my client.
Okay.
Your Honor, it's the state's position that it wouldn't have prejudiced the defense because it was in the booking report.
Okay.
Are you asking us, Your Honor, if I need to disclose trial strategy as far as what our testimony was?
No, but in order for me to conduct a Richardson inquiry, I need to know what effect, if any, disclosure of this would have changed your preparations for trial.
Your Honor, also, being that the facts were disclosed, the defense could have.
Mr. Racinko, I'm not asking you the question.
Thank you.
Yes, Your Honor. In essence, Your Honor, one of the, and I can't get into it without disclosing our strategy, and I'll have to disclose that right now.
So we're not on the record.
We're not on the record? Why are we? Oh my goodness. All right. All right, so now that we are on the record, he went off when I turned off the.
When you press the button.
This is why I shouldn't touch the button. All right, so to rehash, now that we're back on the record.
We're good, sir.
Once again, we are back on the record. The defense has raised a discovery violation indicating that the 3 exhibits that the state had intended to use as demonstrative aids were not properly disclosed and therefore should be addressed as a discovery violation. Hold on, Mr. Gordon. Sure. The state has indicated that they merely intended to use it as demonstrative aids and therefore did not need to be disclosed. The parties have agreed that they were not disclosed prior to trial today. And so the question that must be answered by the defense is, what effect, if any, would this have had to your preparation for trial had the exhibits been disclosed prior to trial?
Do you want to ask the first question since we're on the record? Like, was it disclosed?
The parties have agreed it was not disclosed prior to trial.
Okay. Your Honor, I think our position is that if this was disclosed previously, I could have pressed and find out more details about his path as to where he went and how he meandered through Collier County Boulevard. One of the issues is the U-turn, and I would have prepped, not prepped, but I would have, he and I would, I've shown him the video, you and I would have gone into details as to exactly what road he took to get there. We're not relying on trying to deceive the state or try to present to the state, to the jury, that the route was anything different than what was presented on the video. We're not contesting that. But I think my preparation would have been different as far as trying to explain to him his driving patterns were erratic or not erratic. I would say, I think at this point he would have to testify why he drove the way he drove, meaning he meanders through Collier County Boulevard. The reason why he drove such a lane was to go to a gas station where there were cops, that he had seen cops before, and he wanted to pull into a safe location. And I think these maps that he's now disclosing,
these are, and to be clear, let's be clear for the record, Mr. Singo, these are maps that have been pulled off of Google Earth.
Google Maps.
Google Maps. Okay, so these are just maps that have been pulled off of Google Maps that are, the state intends to show to the jury for the purpose of the officer being able to display what path he took in pursuit of the defendant.
Yes, Your Honor.
Okay. So, Mr. Gordon, so you're saying had the state showed you these maps that are just printed off of Google Maps, it would have changed the way you would have prepared your client for trial?
Correct. But let me put it this way. I'm not,
and prepared your case for trial.
If you want me to stop, I'll shut up and let the proceedings go on.
No, sir. It's just there are three prongs to a Richardson inquiry. And number one, I have to determine whether or not the violation, if there is a violation at all, was willful or inadvertent. I have to decide if it was substantial or trivial, and I must decide whether or not it had a prejudicial effect on the aggrieved party's trial preparation, which is why I'm asking you this question.
I mean, I would have prepped the trial differently. That's the bottom line. I would have, maybe in a better way for us. I never thought of myself even pulling out the map where he went from. I mean, that never came up.
Does a map change your understanding of the facts in any way?
The facts, it doesn't change the facts of my understanding of what happened to the DUI, but it does change the facts to the resistance without violence. That's why I emphasized in my opening, because they also amended the information to include the driving as a basis for the resistance, not the handcuffing. So,
let me ask the state, is the path that the officer took in pursuit of the defendant disclosed either through the video or in some other manner?
It's in the booking report that the defense had access to and was disclosed to him.
The actual path that was taken by the officer.
And it's also in the video that the defense referenced himself just a little bit ago that we went through. I don't see how the defense could have been prejudiced when he had access to all this information ahead of time.
May I answer or not?
Okay.
Your Honor, I don't think in the report it says what routes he took, but in the video it shows the routes that he's driving. It doesn't say Collier County Boulevard. I'm sorry, 951. It doesn't specify the exact routes, but the police, hold on. The police report, I do not, my recollection, it doesn't say exactly what route it is. It says 1/2 mile from Collier Boulevard. I observed an SUV. I was traveling eastbound on Golden Gate Parkway, approximately 1/2 mile from Collier Boulevard. So I think that's the extent of it. And it also says, I attempted to close the distance between my patrol vehicle and the suspect vehicle on Collier Boulevard in the right-hand lane.
All right.
And Your Honor, it also says then it was at Collier and Golden Gate where he turned onto City Gate. Right?
I'm reviewing the booking sheet right now, which is part of the court file and has been, you're telling me has also been part of discovery.
Yes, Your Honor.
The entirety of page 3 of 5 of the booking sheet describes the path that the officer took in pursuit of the defendant in detail as to which road, which path it took, which lane they were traveling in. It is all laid out in great detail. I do not see how a Google map would materially alter your preparation for trial, given that this detail is provided in the report.
Okay.
Therefore, I do not find that a discovery violation has occurred. This is intended to be used as a demonstrative aid, and therefore, any objection to the introduction of these exhibits is overruled.
Your Honor, can I also clarify, can the deputy mark the map?
He can.
Okay.
And then, if you wish to introduce it as an actual article of evidence, then Mr. Gorton, you can renew your objection at that time.
Evidence as for the jury to go back and
Yes. But as of right now, the state is indicating that it's just going to be a demonstrative aid. Now, there's two other quick matters we need to address. You wanted to talk to your clients. Is that right? All right. I'll give you a moment to do that. The other question I have is, where exactly is that TV going to be to play the video?
Right where the easel is. I tried to get it so you can see it, the witness can see it, everyone can see it, and I move over here.
All right. So which way it's going to be pointed at the jury?
The same way the easel is faced right now, that's where the TV would be.
All right. I'll do my best to see it, but I think it's best to stay here. Because the witness needs to be able to see it.
It's been there before, like.
I'll lean forward. I'll be able to see it. Can you see it, sir?
I can.
And that'll work. Perfect. All right. Anything else you want me to address before I give you a moment to speak to your client in the back, sir? All right.
May I use these paper, these maps while I talk to them?
As long as you don't mark or alter them in
No.
any way. State, do you have any objection to that?
No objection.
Go ahead. We'll go off the record for just a moment.
Attorney-client.
we're back on the record. Again, this is State of Florida versus Eric Shane Terrell, 18 MM 2801, 18 CT 2900. Counsel for the state and the defense are present. We're waiting for Mr. Terrell to be brought out. All right, well, hold on, for the record, Mr. Terrell is in the courtroom. Yes, Mr. President, go ahead.
Your Honor, after discussing with him, I can see why I'm kind of, let's say, renewing my objection, but giving you more detail. After talking to him, I think he's mad. I would have prepared my file differently. I would have got a different map to find out exactly where things were, or like the way. What happens is there's two passengers inside the vehicle. One of the passengers had asked my client to take them to a gas station and then home. Then they stopped at a gas station. And if I had known that these maps were going to be used, I would have gone out there, I would have pulled maps and used to show where this individual's house was. Hubert's house was. So I would have done some kind of, let's say, contradictory record, or at least try to supplement what evidence they were presenting as far as the map was concerned. I would have brought my own map and showed where they were going or where he had gone before. And with that said, I do have a printer in my car. I can go get it and see if I can quickly get those maps. If not, that's okay. I can understand. But
what stopped you from printing out maps before today?
Hold
on. Given that, you know, like I said, I reviewed the probable cause affidavit, which does, as indicated, explain in great detail the geographic location where this pursuit took place. What prohibited you from printing out your own map of this exact same area? That's what you would have otherwise done.
Well, in our trial preparation, that has never became an issue as far as, and I think this alludes to the resistance, not the DUI, as to where he was coming from or where he was intending to go. That's why his driving where he was making a U-turn is addressing that issue as to where he was going to. Now, I've spoken to my client. We understand the ruling, but I was just clarifying to try to put on the record. I would have prepared it differently. I'm not saying it was, our strategy would not have been completely different, but trial case would have been different. I would have been going to maps. That's all I'm saying. I would have maybe tried to supplement the map, because one of the things you mentioned is not on this map.
Sunshine Boulevard.
Sunshine Boulevard. So that's why. Now, but it is what it is. So if the court ruling is the same, that's fine. I'll deal with it. It is in the
All right. Even considering the additional arguments presented by counsel, once again, the court finds that given that the contents that the witness is going to be testifying about, which is the geographic location where the events took place, the path of the pursuit that is the basis of the resisting charge, all of which was spelled out and disclosed in the booking sheet, the map which simply shows a physical depiction of what is already described in detail in writing, I don't find this to be a discovery violation. Therefore, any motion to exclude the exhibit is denied.
Thank you.
All right, let's bring jurors back in.
Too broad, you can bring the jury in. They're on the jury.
Jury has re-entered the courtroom. Everyone please be seated. Folks, thank you for your patience. We were able to clarify all of the issues that we were concerned about. We're about to get started again. State whenever you're ready. Please proceed with your question.
Deputy Sorrow, don't just go back here. We had previously spoke about what time of day was your first observed detention?
Approximately 3 a.m.
Thanks. And did you notice the defendant's vehicle?
Yes, sir.
What type of vehicle was
The red Dodge Durango.
it? And do you remember where you were when you first installed the defendant's vehicle?
I did.
Okay. Would a visual aid help with your testimony?
I believe it would.
Thanks. Sir, do you recognize the maps in these demonstrative aids?
Yes, I do.
Your Honor, can I have the witness step down and approach the demonstrative?
Yes, sir.
Deputy, can you please show me on the map, Mark, demonstrative 1, where you first saw the defendant?
Defendant's vehicle would have been right here in this intersection.
Oh, hold on a moment. If our state attorney moves slightly one way or the other, would you be able to see that better, sir? Can you see better now? All right, it's obviously important the jurors can see what you're pointing at. Ma'am, can you see okay?
I can move another way, okay?
No, I just want to make sure that everyone can see. Obviously, we want the jurors to see what you're pointing at. So does everyone have a clear view now? Somewhat. Mr. Rosenko, would you mind just standing next to your co-counsel and speaking loudly while you're doing this portion? And ma'am, is the lectern in your way? It is. Come on.
Your Honor, can I approach this with some post-it stickers so
Sure.
we can mark that?
Remember, Mr. Jury, is that better? Can everyone see okay now? All right.
Your Honor, I do apologize. Would it be possible to move the easel a little closer to the jury? I know it's difficult here to get.
What language would you be willing to use
for everyone?
Oh, no.
Well, hold on, we need to make sure it's close enough to as counsel and the defendant that they can see it as well. Mr. Terrell, if you need to move to the back table, you might get a better view. Now, members of the jury. You good? Can everyone see? No, the jury can all see. Defense counsel, Mr. Terrell, can you see it?
Yes, Your Honor. Yes.
The cameras can even see it. We're good. I can't, but it's okay. Please continue.
Thank you.
I'm not going to ask you to move it again.
Deputy, in Monster Day 1, can you actually first tell me what intersection that is?
This horizontal here is Golden Gate Parkway, and the vertical is Collier Boulevard or 951.
And can you please identify with the post-it on the map where you first saw the defendant? Yes.
I will have the orange part just to be.
What drew your attention to the defendant's gate?
The fact that it was conducting a wide radius turn and one of the tires actually impacted the outside curb, which should be this island with it. There's a curb.
Did the defendant continue on after striking the curb?
Yes.
Did you follow the defendant?
I did.
Why did you follow him?
Because of that impact of the curb, from the distance, it appeared as if it's some sort of damage to the tire.
Where did the defendant's car proceed?
Would have continued eastbound to the intersection of Collier Boulevard and Golden Gate Parkway, and conducted a right-hand turn southbound on Collier Boulevard.
Did you observe a driving pattern?
Not immediately in the pass on Golden Gate Parkway, but I did on southbound Collier Boulevard.
Would you be able to indicate on the map marked demonstrative aid 2 where you first saw the defendant, execute the U-turn?
On demonstrative aid 2?
Yes. Yes, sir.
Yes, sir.
Now, did you observe a driving pattern of the defendant as he continued on?
Yes, on southbound Collier, yes.
What was that?
Originally, when he had conducted the turn on the southbound Collier, he was in the right-hand most lane. When I was able to maneuver my patrol vehicle behind that, he then changed lanes into the left-hand lane once we went southbound. During that time, when we transitioned into the left lane, I observed his right side tires cross over the dotted hatched lines that are clearly marked, and then veer back to the left-hand side of that.
Based on your observation, did you believe the driver was impaired?
At that time, it did lead me to believe there was some cues of impairment. I just did not know what level.
Can you point out on the map when you first initiated the stop for the stop of the defendant?
It would be approximate, and it is not going to be listed on demonstrative 1. It would be approximate size.
How did you attempt to initiate the stop of the defendant?
With my overhead red and blue emergency lights.
Is that how you usually initiate traffic stop?
That is correct.
Did the defendant immediately pull over?
No, I did not.
Did you do anything else to attempt to get the defendant to pull over?
Yes.
What did that do?
I used my audible siren or whales to alert the driver to that.
Did you do anything additional?
At that time, I did not.
So, as the defendant proceeded down Collier Boulevard. What did he do next?
He continued down Collier Boulevard for approximately a half a mile, I would say, depending on scale. He then switched the lane back into the original lane, was in the right, switched to the left, back to the right, and now he's back to the left.
Did he turn off Collier Boulevard?
He did. He would have conducted a left-hand turn after proceeding through a red flashing arrow.
Did he stop the flashing arrow?
He did not.
What road did he turn onto?
From City Gate Boulevard.
After you initiated the stop and turned on the lights, did the defendant have any opportunities to stop, any safe areas to stop? Not along the way.
Numerous.
Can you point out on the map, I believe, I don't know if you can see better on the demonstrative 3, it's zoomed in a little closer. Can you point out on the map areas that the defendant passed that would have been safe for him to pull?
Yes. Here on Collier Boulevard southbound, just before City Gate Drive, would be a hashed yellow lane.
You're on.
Yes.
Can I actually approach and put the demonstrative 3 up on the easel so it's easier for the viewer to see?
Sure.
Yeah.
Very good.
So on southbound Collier Boulevard, there's a hashed turn lane with yellow striping. There would have been ample room and space for not only myself, but other law enforcement. The traffic lines.
Is that the first opportunity for it?
The first safe opportunity is.
But was there any other opportunities for it?
Yeah, all along Collier Boulevard is 2 lanes. He could have stopped in the right-hand lane. We would have been happy to take up the whole lane just because that's safe.
So anywhere along Collier Boulevard, right? Is there anywhere after that that you can mark?
Yes, on the complete route.
Yes.
Yes. Here on Collier, on City Gate Drive, after the left-hand turn, there's actually, you can see it here on the map, there's this one spot for like a vehicle or some very disabled vehicle. That's also lit in that section. You could have stopped. There's a stop sign here at White Lake City Gate. You can go to the left-hand turn again to go northbound on White Lake. Again, there's another section of cut out concrete or pad, which is well lit. I did it with my vehicle spotlight. Vehicle that continued to go northbound on White Lake Boulevard. Again, a stop sign here. This is City Gate Drive North. Where he conducted a right-hand turn. Would have been a hashed line area here. Vehicle that conducted a U-turn in a clearly marked U-turn area. There's a stop there. There's a yellow hash mark as well. Again, anywhere along this roadway would have been great. Vehicle then conducted another left-hand turn, again southbound on White Lake Boulevard, and then pulled into the Shell gas station. Ultimately, he was met by other.
And how long did it take the defendant to eventually stop?
Approximately 3 minutes.
And actually, would you be able to mark where he finally ended up stopping on the map, larger map here? I'm sure.
Mr. Gordon, I'm going to ask you to finally go ahead and have a seat, please. Thank you, sir.
Deputy, what happened when the defendant was finally stopped the vehicle?
He was met by other patrol deputies that were already in position at the Shell gas station. Vehicle came to a complete stop, and we conducted what we call as a felony stop.
Why did he conduct the felony?
Because of the length of the pursuit, time that it took for the defendant to pull over, it becomes kind of a caution to law enforcement there may be something else going on. dangers that we're unaware of.
Objection, Your Honor.
Please approach.
They're going to the uncharged felony stuff. I think this is the ground you're missing. I mean, that's about training and experience. But we're not talking about a felony stuff. He's not charged with illegal. So I think I don't know how to unring the bell. I mean, we're not in training for stealing and leading code. Version. So you asking for a misstep. Yes, you do. And that's, I don't know what else. We may not be able to retry this case. We may not be able to retry this case if you ask for a misstep. Would you like to talk to your client about this? I'm kind of off the road right now. I'm not doing my control. Would you like to take a moment? Yeah, I'll take a moment. And then if you want to meet your objection, you will stay in the objection. Yeah. Yes, sir. Yes, sir. I understand your objection, but I just want to take a moment to really discuss it with your client and how it is done. Yes, yes. All right. You need to speak to it.
Folks, another one of these opportunities for us to have a chat and for you to stretch your legs as a resident. Everyone please rise for the jury.
Please read your notes on your desk where you speak.
We will see you in just a few minutes. Mr. Terrell, I'm going to give you an opportunity to speak privately with Mr. Gorgon about his current objection and how the two of you wish to proceed.
Clear, Your Honor.
All right, thank you. Everyone can please be seated. We're going to go off the record. I'm going to turn off the camera for just a moment. We'll take a brief recess. Mr. Gorgon, I'll give you a few minutes, okay?
Let me just run to the bathroom.
Yep, go ahead. Take a moment.
We're off the record.
Let me go ahead and turn the mics off. We'll be back.
Very fine. Not by anybody else.
Back in the rest.
You're welcome.
All right. We are back on the record in the state of Florida versus Eric Shane Terrell, 18MM 2801, 18CT 2900. Counsel for the state and the defense are present, and the defendant, Mr. Terrell, is present in the courtroom. Mr. Gorgon, please proceed.
Yes, Your Honor, I would ask for curative instructions as far as the felony is concerned. We're not gonna move forward in this trial.
All right. So, state, the objection to any reference to felony anything in this trial is sustained. One of the cases the state had cited earlier in motion in limine specifically does say any reference to the level offense in the matter is entirely inappropriate.
Your Honor,
I agree.
But the witness was referring, what he was using was a term of art, not referring to what this stop was for.
I'm aware of that, but if the phrase felony stop is presented to a jury, they will think this person is charged with a felony. That is not appropriate for the jurors to hear. So the objection is sustained. A curative instruction is the appropriate remedy to this situation. I was thinking about this upstairs. This is my proposal. If either party wishes to amend what I would like to say, by all means, I'm willing to hear. The court would instruct the jurors that the term felony stop is merely a term of art used by law enforcement officers to describe the nature of law enforcement actions for this particular type of traffic stop. It does not refer in any way, shape, or form to the offense being charged or the offense being investigated. How does that sound?
Yeah, yes, Your Honor, that's fine. It's a term of art. It does not imply any felony.
No objection, Your Honor.
All right, let's bring the jurors back in.
Okay, Bravo, you can bring the jurors in.
And we'll
Am I moving
bring the witness
to
back in.
demonstrate again?
What's that?
Am I moving to demonstrate again?
That's up to the state.
I'm gonna ask before they, can I ask them to ask the deputy not to use it?
Yeah, Your Honor, I was just gonna ask if I could have a second to.
Hold off from the jury. All right.
Hold off from the jury.
No, we're good. Mr. Stewart's going to instruct.
Bring the jury in. Please go before you come. Your Honor, the jury.
The jury has re-entered the courtroom. Everyone may please be seated. Folks, before we bring Deputy DeSaro back into the courtroom, I've been asked to give the following curative instruction. You've heard Deputy DeSaro refer to something called a quote-unquote felony stop. This is merely a term of art used by law enforcement officers to describe a type of law enforcement action. It does not in any way, shape, or form imply that this is the crime that's being charged, nor is it the crime being investigated. It is once again used to merely describe law enforcement action for this type of traffic stop. Does either party wish any further instruction based upon what the court has just said?
No, Your Honor, that's fine.
Yeah.
All right, let's go ahead and bring Deputy DeSaro back in to continue the question. Thank you, Deputy. You're still under oath. Sir, please continue.
Thank you, Your Honor. Deputy Sergeant, you previously indicated that the defendant was stopped at the gas station.
Correct.
After the defendant was stopped, what happened next?
He was met by other deputies upon the stop. Some of those who had their guns drawn, and they were removed from the vehicle.
Why was that?
Which part? Why were they met with guns, or why were they removed from the vehicle?
Why were they met with guns?
Because of high-risk traffic stops, such as this, that go on for a time, any length of time lasting 3 minutes, where you see unforeseen dangers, you want to approach the side of the vehicle without knowing what's inside.
Was the defendant ordered to get out of the car?
Yes, he was.
Did the defendant comply?
After hesitation, yes, he complied.
What happened? What happened when the defendant was out of the vehicle?
I immediately took grasp of his left hand or wrist. He was brought to the rear side of the vehicle, where he was attempting to be detained at that time.
And what happened next?
There was resistance during the incoming procedure. Myself and another deputy had used some ample force and leverage for him to be cuffed. He was then brought in front of my patrol vehicle for a pat down.
You mentioned how he resisted. Can you explain each time that he resisted when you were trying to handcuff him?
Yes, initially when we removed him from the vehicle and brought us to the rear quarter panel of his own vehicle, there was some tensing and straightening of the arms.
Objection, Your Honor. I'm gonna ask that this is irrelevant.
Wait, hold on. What is the basis of your objection? Relevance?
Relevance, yes. You've already mentioned.
Oh, hold on. I don't want to speak in objection. The objection is relevance. The question, the question is addressing how the deputy dealt with the defendant, and essentially how was he quote unquote resisting. Is that correct?
Yes, Your Honor.
Overrules.
Deputy, can you please continue?
Yes. But when we handcuff the subjects, we will put their hands behind their back, which their elbows would need to be bent. When they straighten their arms, it separates their hands, making it more difficult. Also, the rotation of the wrist in certain directions, inward and outward, also makes it difficult to handcuff.
Was there anything additional besides what you just explained?
His body placement was turned or canted outwards to either face another deputy, or it should be faced forward.
Anything after that?
Not in that instance, and then there was another incident when he was being packed out of my vehicle.
And then what happened after you gained control of the defendant?
He was handcuffed. I conducted a pat-down search of his persons. Where there was a brief conversation. I advised him that he was being detained at that time. At which point I was going to secure him in the rear of my patrol car. I did give him an escort hold on one of his arms, where he then straightened again and resisted, and he was swatted in my hand.
You're on time at one moment with counsel?
Yes, sir.
Deputy, can you identify in the courtroom the driver of the vehicle that you stopped?
I believe so.
Can you point out for the court?
I'd like to confirm without a mask due to their intrusiveness in the face.
I would object to that, Your Honor. I would stipulate that he is the person that was driving the vehicle for identification purposes.
All right. I'm going to ask Mr. Trell remove this mask briefly, so Corporal DeSaro can see his face, and then he can determine whether or not that's the driver of the car.
I believe that is the driver of the vehicle, yes.
All right, very well.
And Deputy, if I may, where did these events, what county did these events occur in?
Collier County.
Thank you. Okay, back to when you first made contact with the defendant, what were your observations of the defendant?
Upon removing him from the vehicle and placing handcuffs on him, I did observe an odor of alcohol emanating from his breath. He had glassy and bloodshot eyes.
Did you observe any signs of impairment of the defendant?
Just though we had a brief stumble coming out of the vehicle. I'm sure if that was attributed to intoxication level or the force being applied to have him removed from the vehicle. The glassy and watery bloodshot eyes and the odor of alcohol emanating from his breath are two very large indicators of intoxication.
Was it strong odor of alcohol?
It was moderate to strong.
So you earlier indicated that the defendant was handcuffed,
Yes,
and was he placed in your car?
He was placed in the rear of my patrol vehicle, yes.
Okay. And why was he placed in the rear of your car?
For further investigation on the traffic stop.
Deputy, what are field sobriety exercises?
They consist of a number of exercises to determine one's intoxication level. They're done roadside.
Did you suspect that the defendant was impaired?
I did.
Did you ask the defendant to perform field sobriety exercises?
Yes.
Did the defendant refuse?
Multiple times.
Do you know how many times that was?
I don't recall the exact amount, but more than one.
Did you ask the defendant to perform a breath test?
Yes, I did upon arrival at the Naples Jail Center.
Did he refuse?
Yes, he did.
Did you read implied consent?
I did.
What is implied consent?
Implied consent is a Florida state law that any driver who takes on the privilege of the driver's license gives their consent for a blood, breath, or urine test if the officer believes that they are impaired and needed.
Did you recite implied consent from memory?
No.
How did you?
We have a digital printout that's available on our laptops in our car. I printed that out and we bring it to the jail where I read it verbatim.
After you read implied consent, did the defendant refuse again?
Yes, he did.
Did the defendant understand implied consent?
He verbally has to confirm, so yes, he did verbally confirm.
You mentioned your training earlier. Do you have any additional DUI training?
We do yearly in-service training where we are refreshed on DUI, intoxication, also driving clues that we should be looking for on the roadways.
What are those driving clues?
One of them is turning in a wide radius, crossing over lines, unable to maintain lines on the roadway, accelerating rapidly, accelerating slowly, failing to stop for traffic signals, and numerous other.
And again, can you list all of the, any of those that you observed the defendant doing while he was driving his vehicle?
Yes. One would be turning in a wide radius, running the vehicle off of the roadway, failing to maintain a lane, failing to stop for a traffic signal.
Based on all that, did you believe the defendant was driving while impaired?
Yes.
Why did you arrest the defendant?
I arrested him for DUI, operating motor vehicle under the influence, and also resisting arrest.
showing the defense what's been marked Exhibit 1. May I approach the witness?
Yes, sir.
Deputy, I'm showing what's been marked Exhibit 1. Do you recognize it?
I do.
What is it?
That is a audio and video recording from my in-car camera.
How do you know that's what it is?
I reviewed the video and I signed it, and my camera is on that scene.
Does it fairly and accurately depict the traffic stop on 12/7/18 involving the defendant?
Yes, it does.
Your Honor, the state at the time moves this into state moves this into evidence as state exhibit 1.
All right. Any objection?
No, as long as what we discussed about yesterday.
The pretrial matters that were addressed yesterday have been taken care of. Yes, state?
Yes. Okay.
All right.
Would the defense like to review it?
No. See, it's all pre-trial matters addressed yesterday were resolved, correct?
Yes, Your Honor.
Very well. States won't be admitted at this time. I'm going to go ahead and read instructions. Are you seeking to publish at this time?
Permission to publish, Your Honor.
Yes, sir. And it's been pre-marked for the clerk?
Yes, it has, Your Honor.
Members of the jury, you're about to view a video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and consider this evidence. If any of you have difficulty seeing or hearing, please let us know and we'll adjust accordingly, okay? Deputy, are you able to see the screen?
Yes, sir.
Very well. What point does the sound come on?
Collier, just north of 40. He's got a long tire to stop eventually. He's going to Single gas station. Maybe. still wrong. Turn it over now. You take it. And you should not stop. We're going to the shower. We got 3 minutes.
Turn the car off now. Get your dog before you get shot. Drop your dog before you get shot. Get your dog back. You understand English? Shut the car off and put your hands on the steering wheel. Everybody hands up now.
I didn't want to go wrong.
Shut your mouth and listen to what I'm saying. Put your hands on the car and shut up.
Get out of the car. Get out of the car.
Put the stick right down.
What's your deal, man?
You don't want nothing.
You're on the wrong page. Stop moving. Stop.
No, I'm not. I was trying to turn over now.
I saw you crash the car.
No, I don't have power steering. That's what it is. No, I don't have power steering. That's right.
You have any guns, weapons, knives, anything like that? Sharp, hook for sticker?
No, I don't. No, actually, I was just eating right.
You sure?
I know,
What's the keys?
I'm not. I was giving the right one myself. No, what offers this?
Next time you do it,
Give me a big cup.
I know good. What's up?
No, I'm not. Sir, I was trying to go the right way before I went the wrong way. You know how this parking lot's are. I was trying to.
All you gotta do is pull over. I don't care where you pull over. You just gotta pull over.
I was trying to have perspective.
That's all I was doing.
I didn't want to go on the camera the wrong way.
Where'd you go?
Sure. You're clear?
Yes, sir.
The RC?
Yes, sir.
Criminal? Chief? Last name? Zero, spelled like Gerald, T-E-R-R-E-L-L.
Over.
06, 1983.
06.
0609, 1983.
Pretty good gas station for over.
No, I mean, I assume you got a room here, right? I'm trying to run in the house, no?
Just trying to turn that pepper going down the road. Last of and after after first is Eric, after and go Charlie, name S here. We were 6, 9, 8, 3, like that. I was trying to get my report, and I see him do a U-turn. Supposed to U-turn right in front of the car at the end. I did a U-turn right in front of the car at the end, and I went right over the curb. And just pulled over, and kept on going. That's how we have all of them like, I don't know, but that's nobody's got much of it. I was thinking you guys had like shit together.
Well, if that turned into a 31, which was the shortest one, because I was about 26 before sock sticks already. This is all the for female stuff. Yes.
And my birth.
I feel like
She's our turn,
that's not her, is it? I just read it. No, she didn't have anything on it. I haven't asked her any questions, but I don't know what her side of it is. Do you want me to Mirandize her? Talk to her?
Last night, hospital.
Which one? Which side? Where are you? Jamie. Jamie. Matt. You need copper coated bags? That's okay. Because I saw him U-turn in front of Collier, and I was protected the U-turn. I believe he made a U-turn in front of Collier and hit the curb. So I thought we popped the tire and
I could see how driving it looked like that.
it was flat. And he did it hard. He made me start driving off. I got it for at least single one, but I didn't know what to get out of here until I found out what else was in the car.
Yeah, we've had about the phone, the work dog.
I see there's a transport there. Around there. And then I got to check for them too. Computer.
I'm going here. When we got license, I'm not trying to make things difficult.
So from here and to around in the other.
Do you know? Right, I tried to teach you. My practice there, I didn't want to do my own practice.
This is gonna be good, huh? Yeah. So we'll just calm down. Alright. We have the right to remain silent and when we say fair will be used against you in court of law. We have the right to talk to the lawyer and have him present with you while you're doing question. If you cannot put the power of the lawyer, one would do it for me to represent you for any question. If you decide to answer questions now without the lawyer present, you'll still have the right to stop answering at any time until you talk to the lawyer. Do you understand each of these rights that I will explain them to you?
What am I being arrested for?
I have to tell you if you're arrested, but I have to read you these. Which you have other rights.
I understand this.
Alright, and with those rights, you want to wish to talk to me now?
In regards to, yeah.
In regards to the incident of why I stopped this vehicle.
And why was I stopped?
Because you're driving erratically, you drove off the curb, when you do a U-turn in front of the car lane, then you have to stop for, I'd say it's not
Yeah, no, I had a reason for that. It's because I didn't want to go down the wrong way and I wanted to pull over in a proper place.
like, when you move here, number of intoxicated.
No, I wasn't drinking at all.
Do you wish to talk to me?
About what?
About this? Well, I just told you.
Well,
Yes or no? Yes or no?
Yes, I have a question. What was the initial stop, reason for the stop?
If you're out driving and jumping over a curb.
Okay, when I did the U-turn, it was a legal U-turn, and as I'm going over a curb, I don't have power steering.
You went over a curb.
The power steering is not.
Okay, well, that's it, what's the violation?
What is that?
What's the violation? You're talking about standards.
It just wanted to.
Okay, are you talking here now?
I am.
Yes.
You will honest with you. Yes. To be honest with you, but basically, I put the power steering pump out.
I'm not worried about the power steering pump.
That's why I did it.
You said you took from work today? Is that where you're coming from?
Well, after I put the power steering pump in, it didn't work. It's still leaking, so the power steering pump is
I'm not
not
worried
working.
about the power steering. Where are you coming from?
Well, I told you I was dropping them off from work.
Where are we taking them?
Home.
Where's home for them?
Like a block from where we're gonna go to the gas station, get drinks, and take them home. I'm a nice guy, I don't know how to say no, and if they ask me to.
Where is home for them?
A block away from here.
About from where?
Sunshine, green ball.
Yeah, that's not it. You're actually a lot closer when we made the U-turn.
Yeah, basically we were coming to the gas station.
There's a gas station on the corner, so what's speedway?
I pulled in there because I already knew I was getting pulled over and I seen the police and I know about.
You haven't before you started driving today.
Nothing.
So I'm spending you over alcohol beverage from you for no reason?
Well, I'm not saying that I don't drink, I didn't have any drinks within the last 6 to 8 hours, I didn't have any today at all.
Nothing. So the erratic driving is just you?
It's the power steering pump, okay, explain.
Yeah? Any of your passengers?
As I said, that I worked with them on the ride home, and the nice guy offered me.
You work with them, so you know them.
I know it was work.
Okay. So are you aware of any illegal narcotics that may be inside your vehicle?
There should be nothing in there whatsoever.
There should be.
As I explained before, I was a personal trainer, moved down here with my room. and he passed away. I got my dog, that's my dog, me and my daughter, that's it. But I don't want anything else. I don't already know nothing to hide. I'm not a.
They look at the fact that still be murder, alcohol, but that's standing outside of the car.
I had 3 or 4 people in there, and that's.
So that's something that was sent to them from those people that are off of you?
No, I mean, that can be hearsay. I mean, I didn't do anything. I already explained to you, and
so what did you wrong to submit your protesting?
there's no reason for you to do that because basically,
I believe you're right.
yes, sir.
Are you willing to submit to sobriety exercises to sound like really intoxicated?
Sir, I'm working. I don't know all night.
Are you willing to submit to field sobriety exercises to dispel my fear that you have not been drinking alcohol?
You may be arrested for DUI, so I have no reason to do that.
Are you willing to submit to field sobriety exercises to prove me,
But I don't know, to be perfectly honest with you, I would love to.
Are you refusing?
I can't. I cannot do that, no.
You cannot use field sobriety.
There's no reason that I should have to do it because I wasn't drinking.
Well, then I have, based on that, I'm gonna tell you how it operates. I have to do it based on my assumptions and based on what I've seen, based on what I smell and observe, okay?
So you're going to phone the car and arrest me for whatever reason?
Based on the totality of circumstances of what I've seen tonight, what I smell coming from you, and the driving that occurred, the air driving. Unless you complete field sobriety exercises and prove you're wrong.
So you're telling me if I do a road test walk and I pass, so what do you require?
We don't do roadside blood tests for the jail. Okay? When we're out here, we do 3 exercises. Okay? We do one that has just nothing to do with your eyes. Then we do a walking turn and a one-legged stand.
Okay. All I'm saying is I've been nothing but antagonized and alienated my whole life. And what's going on right now? I mean, my whole life except
You don't want to complete that bracket.
I didn't say that I didn't want to, I said, what is the term? I didn't want to go to jail, I didn't want to make you go to jail for no reason. For what I didn't do.
Yeah, there wouldn't be an opportunity for based on what
I just don't know the reason for that, the right time, we're not gonna, it's not gonna be able to do it. Alright, I was doing nice guy, and we don't have to look at it.
What they're talking about, how you're going to deal with it. Okay?
What I'm explaining to you is that I was being a nice guy, I was dropping my friend off that I worked with, and that now I'm in handcuffs. That's pretty much it. I have a job to worry about.
You guys pick up the domestic animal services clinic. You can pick up your dog afterwards.
For what though? For what?
Because they're going to take care of the dog.
Okay, so, but, and I didn't go to the jail, so what? I said, I will do the test at the station with the spirit, with the rocks.
Okay, that's the back test.
I will do the walk, whatever you want me to do. I'm not intoxicated. I'm stopping tonight off and doing a favor, dropping them off. And because I turned around, because they didn't know where they were going.
Let's go to this place right here with me.
Yes, sir.
Nobody else.
Okay. And so, I'm looking at the person that, like, knocked me to the jail, that's all. Listen, can I come outside for a minute? No, do whatever you want me to do.
The reason for
That's not one. Yes, sir.
when you're done,
I have been engaged to you. When you got me in trouble in the first place, I have good dad. But sometimes it's blessing and sometimes it's curse. It's no disrespect whatsoever. My family is police officers. I completely.
It's no experience, or not?
You know what I say, like, you're gonna just make me go through it, you don't like what I have to say, and I talk too much.
all you do is burn out.
I mean, yeah, it's, help out, I don't think it is, I think it's, shoot me. So if I go right now, and I go less than I should, then I can go home, or I can park my car and walk. Put my dog home, and I don't care about it. I don't care about my dog, everyone
That's pretty much it. We give you the opportunity there.
I'm great, I'm gonna be right, and I said, I'm gonna need it. How about we just let you just put mine over and let me go?
Yeah, that's not gonna happen. That means you said it.
How are you putting me into the DUI or refusal?
Because you refused.
I didn't refuse.
You did.
I didn't, I mean, it's serious.
You need to get more up to the end, things recorded.
Well, everything you see recorded is basically I asked questions and I stated that I was confused. Anything as far as the roadside systems.
Okay, so you're gonna provide a breath out. The breath test will be in the air.
But we were sort of using the mill rather than the fact that you say a rare.
Is that reckless driving?
What's that?
Reckless driving?
Instead of rag cracking, you can say reckless.
Drafting?
Is there a difference between rag cracking and reckless driving?
Maybe.
But initially you said rag cracking.
Yeah, you hit a curve.
No, I ran over a curve due to the fact that I don't have any power steering on the whole thing. I mean, that's all for court, but we really have to go on that access. I mean, you can't just cite one or whatever you want to cite me for and
Maybe, so.
on zero.
Just hold on, we'll do the question. State, any more questions?
Just a few. Deputy, you had mentioned, in the video, the defendant mentions was looking for a proper place to stop. Did the defendant have multiple opportunities prior to reaching the gas station?
Yes, as I displayed in the earlier report.
You'd also mentioned you read the defendant implied consent.
That's correct.
Do you have what you read to them with you?
I have it available for that, yes.
like you to read exactly what you read to the defendant for implied consent.
This printout's available on our internet for the Collier County Sheriff's Office, so same printout that I would use that day. This is a state of Florida implied consent warning for breath testing. I am now requesting that you submit to a lawful test of your breath for the purposes of determining its alcohol content. Will you take the test? Below it notes that if the answer is no, to read the following. If you refuse to take the test I have requested of you, your driving privilege will be suspended for a period of 1 year for a first refusal, or 18 months if your driving privilege has been previously suspended for refusing to submit to a lawful test of your breath, urine, or blood. Additionally, if you refuse to take the test I have requested of you, and if your driving privilege has been previously suspended for a refusal to submit to a lawful test of your breath, urine, or blood, you will be committing a misdemeanor, in addition to any other penalties which can be imposed by law. Refusal to submit to these tests, as I have requested, is admissible into evidence in any criminal proceeding. Do you still refuse to submit this test?
Did the defendant say that he understood?
Yes, he did.
And he still refused?
That's correct.
Also in the video, there was mention of Zookies. Can you tell me what Zookies is?
Zookies is a local bar and grill located on Monkley Road.
And he said he had worked there at Zookies.
Yes, just very briefly in the beginning.
No further questions, Your Honor.
Thank you, sir. Before you step down, would you please wipe down the lectern?
Yes, Your Honor.
Thanks, sir. Either readjust it slightly to your left, or I'm going to ask you to sit at the table just move it away so you can maintain social distancing from Mr. Collier. Okay. Thank you, sir. All right. Defense counsel, any questions?
Yes, may I?
Yes, please proceed.
I'm sorry, is the video still in the machine?
No, sir.
I did remove it. I didn't.
It's been removed, but if you needed to play any portion of it, you have access to it. Did you need to play a portion of it?
Yes, I may be playing. Yes, I have my own laptop on, but they won't use the same laptop.
No, that's fine. State, I would ask if you wouldn't mind, before the question begins, just go ahead and reinsert the disc. And that way Mr. Gordon can play it as he sees fit. Thank you, sir. Counsel, please proceed.
Before we begin, I just think of asking, you have 8 years as a deputy, correct?
I had 8 years with the Collier County Sheriff's Office, approximately or just a little over 4 years as a road patrol certified law enforcement officer.
Okay, I think the question was asked, was 4 years communications and 4 years road patrol?
That's correct.
Now, we watched the video on this, and we watched the video, and it's your interpretation that this U-turn that you made was a wide U-turn.
That's correct. Wide radius.
Okay.
Mr. Gordon, what are you doing?
I'm thinking right now, actually.
Okay.
Your Honor, what I was going to do, in order to keep the social distance,
Yes, sir.
I was going to try to see if I can play it from here, so I don't come close to the deputy.
Can you control the laptop from there?
I believe with the mouse, I'm saying in church.
Is it connected to that laptop?
No, Your Honor, I'm going to connect it with the.
Your Honor, we object to defense counsel connecting his mouse to the state's laptop.
Okay, you want, I can be more happy if Your Honor use my laptop.
All right.
That's fine.
How long will it take you to connect your laptop?
Let me finish with the question, then I'll connect.
Very good.
Now, one of the questions that was asked is that you use various methods of trying to notify the defendant to pull over, correct?
That's correct.
And I think you said a siren?
Yep, that would be our in-car audible siren, which you've heard numerous times in the audio video.
And then, I think it's also on the video. Did you use your, I guess it's a loudspeaker?
Yeah, it's a PA system or public address system.
Okay. Now, you also mentioned something about flashing arrows. That's what I was going to ask. What is the flashing arrows?
But those are the red flashing arrows above the intersection, which you have to come to a complete stop and then proceed with driving through the intersection. That would be at City Gate and Collier Boulevard.
Okay, so it's got nothing with your car, it's just signal.
That's correct. Traffic signals.
Okay. Now, the driving pattern, I think you mentioned that initially there was an accused of impairment. But I guess later on, there were more cues of impairment?
And the first cue would be to run the vehicle off of the roadway and onto the road. That would be cue number one.
Okay. How about this? I'm going to lay off these questions, and then once I start playing it, I will address them.
Absolutely.
Okay, you know what? I'm going to ask right now to, I guess I'll hook up my laptop and then play it see if I can play it from here.
And your mouse will control your laptop from there?
I know it's got I want to go back from here.
And so I guess I'll ask my question again. How long will it take you to set up your laptop? So I want to know if I need to excuse the jurors for a moment or not.
I think it'll take a second. All I gotta do is just look it up. Give me a minute.
Sure.
Or
Folks, would you like a comfort break, or are you okay for a moment?
okay.
They're fine. All right, go ahead, sir.
I don't know how you want to proceed with this.
You can go ahead and approach. Steve, if you wouldn't mind unhooking your laptop first, get the disk out before you do that.
Yes, right.
And then the disk out, unhook your laptop, and Mr. Gorton, you can go ahead.
Oh, wait a minute, it's got a
HDMI.
I don't think I can understand. I'm sorry.
You do.
No, I don't.
Okay.
It's an
It's in the
HDMI.
upper left-hand corner. Left-hand corner.
Those are USB drives.
Both of them?
Yeah, that's fine.
All right.
May I, Your Honor, has permission to use the original laptop that's on there? I was not aware that they had an HDMI connector.
Steve, Mr. Gorton, use your laptop,
Right,
please.
connected.
Please. That being said, Mr. Gorton, the state is very concerned about any peripheral devices being plugged into the laptop that isn't approved by their IT division. So you'll just have to stand there and use the laptop control. Just, their IT division is very strict about what they're allowed to be plugged into their computers.
I just didn't want to stand there.
I understand. But I'm afraid, we'll have that limitation. You'll have to do that. There we go. Thank you, Mr. Asenka. Mr. Gordon, you may approach and play the video as you see fit.
Correct. I'm going to be stopping and asking a question.
Of course, sir.
Okay. Can you see, sir?
I can.
Okay.
Your Honor, would you like me to, and in defense, would you like me to play the timestamps while?
No, Mr. Gordon is in control of it. Thank you, sir. Thank you for offering.
I'm going to stop. When I'm ready to stop, I'm going to stop.
When you're ready to stop, just approach and hit pause.
Yeah. I'm going to approach you on that.
Go ahead. Go ahead and pause real quick. Steve, you don't need it at this very moment. I don't need it at this very moment, but do you have a power? At this point, Mr. Gordon, are you having problems or are you pausing?
No, you're on. I promise. I don't think it's got a pause button. This is a, I don't know why it's got no pause button.
Okay, folks, we're going to need just a moment to sort out technical difficulties. Go ahead and stretch your legs, get a cup of water, grab a snack if you'd like to. We'll see you in just a minute.
All rise for the jury. Leave your notes on your chair.
Maybe it doesn't pause. I did notice when we were playing.
Jury is clear, sir.
I'm going to go ahead and turn off the microphone. We're going to be in recess. Let's go off the record, figure it out.
Sure.
I'll be back.
We're off the record.
Thank you.
You're welcome.
When you told us what the pause right there, but where is it?
We are once again live streaming. Before we bring the jurors back in, state, Mr. Gordon.
Yes.
I was reviewing the proposed jury instructions. I was going to tell the state now.
Yes.
There's another instruction we're going to need. It's 3.12A, single defendant, multiple counts or information.
Correct. That's what I was going to allude to, Your Honor. And just to give you my opinion.
No, that's in addition to 3.12.
Correct.
Yes.
And then 3.9B.
Sorry, Your Honor, can you repeat those?
Yeah, I think that's in there. 3.12A, single defendant, multiple counts or information, because that is what we have. And then Mr. Gordon is asking for 3.9B.
Correct.
Your Honor, I do have 3.9B here.
Very good.
Also, on the verdict form, it's got 18 CT 290. That's incorrect.
It's 2900.
No, that's not the issue. It's 18 CT 290. That's for count 1 driving, and it's got count 2 resisting. It should be one count, and then a separate verdict form, count 1 resisting, and also with bottoms with 18 mm 2801.
I agree. State. There should be 2 separate verdict forms because there's 2 separate informations.
I agree.
It does not 2 counts, it's 2 informations. So perhaps that's 3.9B?
Yes.
All right. Please. And perhaps one of your colleagues can print out 3.12A. And fix the information, because we will need, we fix the verdict form because we need a separate verdict form for each count, because the informations, there's 2 informations that were brought. Because they weren't consolidated under one case number, they were just being tried together for trial. Well, let's go look at the order, actually. I did sign an order. All right. Yeah, they're not being consolidated on one case number or one information. The cases are just being tried together, so we do need a separate verdict form for each case number.
Oh. Let me know when you're ready, Your Honor.
I'm ready.
On the weighing, look over here.
Yes.
On weighing the evidence, I noticed there's 2 different ones.
Yes, one has defendant testifying, where he says the defendant is to whom a witness in this case. The other one leaves that out because then we have the instruction for defendant not testifying.
Correct. Now, I also noticed they got number 6 in here. It says, did the witness at some time make a statement that is inconsistent with testimony she gave in court?
Right.
When I don't think I'm going to be making any prior inconsistent statements by the deputy. I don't think there's any issue. I don't think that there's any inconsistent statement that she'll be making.
Those 6 are pretty standard. If you want it out, state. I can't address that until we finish all testimony.
Correct. I don't foresee that happening.
I know, but it's too early to make that determination until the testimony comes to a close.
Correct.
All right. All right. Anything else?
I don't see it. That's all.
Anything else?
No.
All right. Ready to bring the jury in? Yes.
Yes, I'm
We're out waiting to bring the jury in.
Print out the verdict form to this printer. It should be able to print it out.
Okay.
Holding them up. Sir?
Yes, please. Is there a way you can prepare them and we'll print them out in a few minutes because it's already photographed before?
It's printing out here.
All right. Yes, please. But we're going to need the CT one as well. So let's just do this. Just have it prepared, get it on your computer. We can print it out the next break. Let's go ahead and bring the jurors in.
Your Honor, the jury.
All right. All right, everyone please be seated. Members of the jury, I believe we have solved our technical difficulties, and so we can go ahead and proceed. Mr. Gordon. Yes, sir.
By this time, had you activated your light?
Yes.
Mr. Gorgon, if it's okay with you, you can question from there.
Yes, Your Honor, thank you. I will keep a social distance though.
You're good exactly where you are. So if you want to pause it and ask a question from where you are right at that place, you're fine.
Thank you.
Yes, sir.
I'm gonna stop it right here, sir. By this point, you had turned on the light, you had turned on an additional light?
That, yeah, what you see is that bright white light that's emanating from my side door that's manipulated by my own left hand.
Okay.
Spotlight.
And I have forgotten to ask you this, but when you began the siren, sir, when I'm playing the video, can you tell me where, in your opinion, would it have been a safe spot to turn to for a roadside, I guess, a DUI investigation?
We've already passed it.
Okay, I will start then. I'm gonna start at 51 seconds. And I'm gonna start it again. At this point, at 51 seconds, there is no DUI indicators, correct?
We've already had one where he hit the curb and then one where he has already been in the left lane. That center lane, how it's split and divided.
Yes, sir.
He crossed over that when he was in the left lane already. We've already seen 2 indicators for mine.
Okay. And it's at this second, 52, that you turn on the sirens.
Yes, the microphone will also activate at the same time.
Okay. Your statement or your position that up until this point, he has a chance to pull over?
Yes, it wouldn't be extremely, advised at this point because it's a 2-lane dark road. So at this point, he can pull over if he feels comfortable doing so. I feel comfortable with that, but it is not the optimal place for a DUI investigation now.
Okay. Now, that's what I was going to ask you, sir. At this point, it's your position that it's okay to pull to the side of the road to conduct a traffic investigation, or at this point you've already had some cues of DUI?
I did have some cues of DUI. It would be an acceptable place for a standard traffic stop, yes.
But
For a
not-
DUI investigation, it would.
I'm sorry, this is at 126, your siren is turned on.
Correct.
No, okay.
I apologize for stopping you. At this point, I would see that there's multiple clear spots on the right-hand side to conduct my DUI investigation.
On the right-hand side, over to that side, I'm sorry, I'm pointing for the record, to the right-hand side of the video, you're saying that he could have pulled over to that side in order to conduct a DUI at this junction.
That's correct. It'd be the westbound side of my airport.
Let's stop right here. I'm sorry, when you made the left turn, where is he left turning onto, sir?
This current is City Gate Drive, I believe it is.
At this point, is there any position from, I understand you already mentioned that there was a safe place on the right-hand side, that was 951, correct? But he made a left turn. Is there any safe position at this juncture to pull over for a DUI investigation?
Yes, we're actually looking at one right now on the right-hand side.
The right-hand side.
Approximately 2 seconds back, my spotlight illuminates that area where it's nice little pulling for my 2 vehicles.
Okay. You being right here?
That's right. My spotlight will come on.
Okay.
And it will, for the record, it will stay on the right-hand side of the video. You'll see a nice opening where my spotlight hovers just for a brief moment.
I'm gonna mute this so you can talk when we're playing, so to speed things up, okay? So, right there?
Right there. There's a pole, and just to the right of that is an open area where cars are normally able to pull over.
Okay.
As my spotlight remains on, there's another spot on the right-hand side, very similar to the last one that we saw, with this open pavement. That would be an acceptable place for me to stop. It's coming up here just a couple of seconds.
Okay, but not this spot, correct?
Not this current frame.
Let me know
Right
right
there.
Okay, right there? Why, let me ask you a question, sir. Why is that spot a very good spot to do a DUI?
It is an optimal place to do a DUI because it's open area and open space. If we were to do it and conduct it in this lane, we would be blocking the flow of
I
traffic.
understand. Are you referring to, it's in the middle portion of.
You're okay, Mr. Baker, you can stand up. I couldn't kneel that long either.
You're pointing into, I guess, for the record, on the right-hand side, middle portion, I guess in the right-hand side, the middle portion of the area where the road turns, I guess, to I don't know what that is, a road or a dead end. But you're saying in that area, that would have been an appropriate spot to do a DUI?
It could be, yeah, I would be open to that as well.
But there is no lighting there.
No, there doesn't have to be any lighting or lighting posts for me to conduct a DUI investigation.
Okay.
My forward headlights on my vehicle would more than suffice.
Do you know where that road leads to, sir?
It is a dead end.
Okay. Does it have a street name?
No, it does not have a street.
Okay. And just out of curiosity, would these areas be conducive?
If he would have made a left turn, he would have already been in the gas station for an example line. Yes.
But not there?
On the right hand side?
Or yes?
I didn't remember seeing one right there.
Okay. Would this area be a good spot for a DUI investigation?
It'd be wonderful. It's a well-lit area. It's a non-traveled road. This is prior to the construction of the baseball field, so all that in the background. So no cars can come down that way. It is well lit, yes.
And I'm gonna point to the right-hand side in the middle section. Is that area a dead end also?
At the time of this incident, yes, that is a dead-end construction zone, about 500 yards, maybe more.
Okay. Now, let me ask you a question here. When he pulls in here, would the gas station be a good place to conduct a DUI investigation?
It can if it is an immediate option.
And let me ask you this. I'm gonna walk back to my post, to my stand to the podium. Would it be in your judgment, would the gas station be the most optimal location of all the locations that we just passed by? The best place to do a DUI?
The well-lit area would be the best place to conduct a DUI investigation, yes.
Okay. I'm going to keep it on mute. I'm going to turn on the volume.
Drop your dog before he gets your dog back. Do you understand English? Shut the car off and put your hands on the steering wheel. Everybody hands up now. I don't want to go wrong. Shut your mouth and listen to what I'm saying. Put your hands on the car and shut up.
Was that you or was that somebody else?
That is not my voice.
Get out of the car. Get out of the car. Put the cigarette down.
Okay. Let me ask you a question. At this point, I think you mentioned that you had to pull him out of the car. Is that when you say happened here, that you pulled him out of the car?
I already had my left hand on his wrist at this point, and I did pull him out of the car. He had a cigarette in.
Okay. He was holding a cigarette. Who opened the door?
At that point, I don't remember if it was myself or Sergeant Brad.
Was it him?
I don't remember.
Once you do that, let's try to go. You want to go the wrong way. Stop moving. Stop. No, I'm not. I was trying to turn over now. I saw you crash the car.
By the way, is that you, sir?
It is.
Okay.
Sure. No, I don't have power steering. That's what it is. No, I don't have power steering. That's fine. You have any guns, weapons, knives, anything you know about? Sharp, close, grip, stick? No. No, actually, I was using right in my work, sure. Because I know, no, I know, No, I'm not. I was getting them right home, that's it. No,
kid. Next time you do it, it'd be a big problem.
Now, when you say that, was he resisting up until this point, or has he resisted?
When I went to give him an escort by the right arm, that's my new, I'm gonna take him to the rear of my patrol vehicle. That's when he straightened his arm out and resisted. And there's a brief minute there, or a moment there, where you can see a spot in his hand.
Okay, I didn't understand.
A spot, like a slap towards his hand,
Oh,
of my grasp of him.
okay. So that's the act of resisting and all.
Yes, I mean, the word there is resistance, yes.
Sir, I was trying to go the right way before I went the wrong way. You know how this parking lots are. All you gotta do is pull over. I don't care where you pull over. You just gotta pull over. I was trying to look this parking lot. So I didn't want to go anywhere in the wrong way. Where's your wallet?
Okay. Now, at this point, he's been placed in the backseat of the car, correct?
Correct.
And at this point, is he handcuffed?
He is.
Okay. Now, you asked him multiple times to perform some field sobriety exercises there?
That's correct, as we watched earlier.
Okay. Let me ask you this, sir.
Sure.
Do you refuse to provide some kind of the field sobriety exercises? And did he refuse at the jail as well?
We do not conduct field sobriety tests at the jail. That's what it's called, field sobriety tests.
Okay. And so when you took him to the jail, that's when you asked him to blow into the machine?
Yes, he would have to be, you'd have to conduct a lawful breath test. The breath test operator who is certified with that machine, and which when if he refuses, I would imply consent.
Sure. Also, at this point, not at this point, but in the video, you started some, the exact time, I don't have, I'm not gonna fast forward it for time constraint reasons. But you start asking him some questions after Mirandizing him, correct?
That's correct.
And when you Mirandized him, did you believe that he was answering truthfully and honestly?
I believe he was being truthful. Some courts, his directions may have been a little off.
Okay. Now, there was an issue about the mask. Approximately, you said the driving period for the resisting was, for the driving was 3 minutes long.
Correct.
But there's actually, if I were to show you on the video that it's actually 4 minutes, would you, the 1 minute was not part of the 1 minute,
I would not conduct or count the minutes prior to my lights activating for a traffic stop. Those are my time, that's my time to investigate the car and how it's traveling.
Okay.
So from that point, from my lights and my microphone activating my car, that's where I will start my timer.
Okay. Now, also, there was only one U-turn, correct? On the video, I could see only one U-turn.
There would be 2 U-turns. One was first conducted in front of the hotel at Quality Inn. The second would have been conducted on City Gate just before pulling into the gas station.
Okay.
It's kind of a U shape, but it is a U-turn.
I see. And the first one, I think we cut, I didn't play it, but it's the very beginning.
Yeah, it'd be very difficult to see with our old video camera systems.
Okay, but it is on there, the first one?
It should be on the video. It is. It's more than likely difficult to see.
Okay. Let me just play it.
It's because of the distance. Our cameras are not at this time, 2 years or 2.5 years ago, is not high definition capable. So
Okay. Let me just replay it for you, sir.
So about this point here, you can see two very faint tail lights ahead. That would be the day one question.
I mean, the defendant,
The defendant's vehicles are, yeah, it's already made a right hand turn.
okay, sure. Is that him right in the middle of the
That's
picture in the
correct.
record?
Yeah, the sole vehicle in front of him is correct.
Okay. Now, at this point, he has not made a U-turn.
He did make the U-turn in front of the hotel, which is the first reason for my stop.
Okay.
He impacted the curves.
Okay. So, hold on. So, there is, I'm gonna stop at the wrong 1 minute. So it's not on the video, the first U-turn?
No.
Okay. Now, let me ask you a question. As far as, that once you get to the station, he would blow? You recollect him saying?
Gas station, are you referring?
Yes, and once he's in the car, you asked him that, once we get to the station, we would blow.
Yeah, you're saying station though, and I'm confused between, are you referring to the gas station or the police station?
Let me rephrase the question. You're absolutely correct. Let me rephrase the question. Does he say somewhere in the video, towards the end, that once you get to the police station or sheriff's station, that he would blow?
Did he agree to it?
Yes.
No, he was very elusive in his answers. He did state that he would complete field sobriety exercises with a superior officer at the Naples Jail Center, which is not an option.
Okay. By the time you transport it, there is no option of doing field sobriety exercises.
No, because once we secure a subject in our patrol car and we leave the scene of any incident, that is an arrest. He's going to the jail for that reason. I can't do an investigation outside of that scene.
Okay, but let me come back to the Miranda. At that point, when you, let me rephrase that question. Before the Miranda, when you placed him in the back seat of your car, he was not under arrest?
At that point, he was being detained for my investigation.
What about when he scuffled and whatever the arm wristing is, the arm twisting? Was he being detained or arrested for resisting an officer?
At that point, he was detained. The resisting arrest is a charge. Had he completed field sobriety exercises, it might have been a different story. We can't leave that.
So the resisting has got nothing to do with the field sobriety exercises?
No.
It's got to do with the fact when he was getting out of the car, whether it's you, by your own devices or his devices, he was struggling. That's where the resisting came.
Correct.
And you redirect? State any redirect?
Yes, Your Honor.
Hold on. Mr. Gorgon, I do have to ask you to follow our COVID protocols, please, to do a quick wipe down of the lecture before the state approaches it.
I didn't understand you, sir.
I need you to wipe the lecture
Oh,
down.
I'm so sorry, yes. I did it last time.
Yes, sir. It's okay. I have trouble remembering too. Thank you, sir. These procedures are by...
And rather than caution, I'm gonna clean the laptop.
Thank you, sir. Thank you, Mr. Gorgon. State.
Thank you, Your Honor. Deputy, so when your lights turned on, it was 3 minutes after you turned on your light until the defendant stopped?
Approximately, I don't have the exact time.
Okay. And you used your lights on the top of your car, your siren, and the sound system? PA system, and the spotlight?
And the spotlight.
Okay. And did the defendant first pass the gas station? Was there an opportunity to turn into it at first?
Yes.
Okay. Now, you activated your lights, and it took 3 minutes. Does it usually take people 3 minutes to pull over their vehicle?
No, it does not.
Do they usually respond?
I would say in my experience, and on day shift and night shift, both in the last 4 years, vehicles will pull over in 10 to 15 seconds.
Talking about indicators of DUI, what are those again that you saw the defendant?
On this person's, it would be watery or bloodshot eyes, the smell of odor or alcohol.
Your Honor, I'm going to object. This is beyond the scope of my cross-examination.
Sustained.
We looked again at the resisting where the defendant was twisting his arms and swatted his hand away. Did that make it more difficult for you to place him under arrest?
It does. It just compounds things a little bit. It does make it more difficult to escort him. Okay. If someone were to resist further and they're standing on their feet, it could result in people falling on the ground, getting injured beyond. If his hands are bound, there's no way to protect himself from falling, or if he runs away, things like that. So you have to watch out for injuries.
And when a defendant does not, when you turn on your lights and for the defendant to pull over, attempting to stop them, and they don't pull over, does that obstruct your traffic investigation?
Yes, and what it is, I could have and probably should have now in hindsight announced to my dispatcher that it was a pursuit, or I believe it was a 31 Victor, it's a pursuit in progress. Vehicle doesn't stop creating problems for the public as well.
Okay. All right. Is this witness free to leave, or shall he remain under subpoena?
I have not subpoenaed, so I have no objection to him.
See?
If the defendant's going to be called.
Mr. Singhal, we will address that in a moment. My question is this witness subject to recall under subpoena, or is he free to leave?
He's subject to recall.
All right, thank you, sir. You may please step down, but remain nearby if we need to call you. State, please call your next witness.
No more witness.
All right. And therefore? All right. Folks, this will be a very quick break. We need just 5 minutes to have a quick conversation outside your presence, and then we will proceed with the remainder of the trial, okay? All rise for the jury.
All right, you go to your chair.
Clear, Your Honor.
Please be seated. Mr. Gordon, you have a motion.
First two motions, judgment of acquittal, and furthermore, I did not hear venue. I did not hear.
I did.
You did?
Yes. It was asked if this occurred in Collier County, and the answer was yes.
More importantly, Your Honor, I'm going to be asking the JOA on, I think the state has established the JOA, there is no judgment of acquittal argument to be made on the DUI. I think the evidence is clear that my client was in physical action control of the vehicle while driving. As far as it's a jury question, as far as impairment is concerned, I don't think any refusal affidavit was submitted into evidence. But that's, I mean, I would make a bare minimum JOA on the DUI for the fact there was no affidavit of, whatever that affidavit is, I can't think of.
It's commonly referred to as a refusal affidavit.
There you go, thank you.
All right.
Furthermore, I don't think the evidence showed that my client was anything to the, where the normal faculties were impaired by either drugs or alcohol.
Okay.
With that said, let me go on to count two, or I'm sorry, not count two.
The second charge. Yes,
Second
sir.
charge, Your Honor. Yes, Your Honor. The second charge, Your Honor, the state made an amended information. And in the amended information, they stated that, and I brought it out in the opening statement, that it was a resisting of violence.
Without
Violence, and second amended.
I'm looking at it right now. This
Yeah,
is in the case.
conducting a traffic stop contrary to Florida statute. In the first original, I believe, resisting, it was the resisting where my client was, I guess, pulling back on his wrist. I think the state, second amended information, does not, in the best evidence light possible for the state, does not meet, the facts of the case does not meet the statute, in the sense that there was no, that the driving was not part of the driving of the defendant was not the act of resisting. The officer said the act of resisting was when he was outside and he was taken out and he resisted by moving his arm, making it difficult for him to be, for the officer to arrest my client. I would argue that at this point that there was no act of resisting pursuant to the second amended information.
Okay.
If you want, I can read the information, Your Honor.
No, I've got it in front of me. Thank you. All right. Anything further, Mr. Gordon?
No.
All right. State a brief response.
Yes, Your Honor. It's the state's position that the traffic stop included the officer attempting to pull over the defendant, as well as the events that occurred once the car was finally stopped. Therefore, satisfying the requirements for this charge.
I agree. The motion for judgment of acquittal is denied on both counts. All right. So, Mr. Gordon, do you need any more time to talk to your client about whether or not he wishes to testify, or are you prepared to address that now?
It's our position, Your Honor. I've been talking to him in the back. I've had my conversation. He wishes to testify, but I want to confirm.
Sure.
Yes, Your Honor. He wishes to testify.
He does wish to testify. All right. Then, Mr. Charles, I'm going to ask you to stand and raise your right hand, please. I'm sorry. Yeah, we can do the left hand. It's all right. I remember. I'm sorry. You told me last time. I say it so much.
No worries. I appreciate it.
All right. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Thank you.
I can put your hand down, please. All right, sir. We previously talked about your right to go to trial. Another fundamental constitutional right is the right to remain silent and the right to testify at your trial. Do you understand?
Yes.
Now, as I had indicated before, you do not have to say anything today. You understand that?
Yes.
You don't have to appear before this jury and answer any questions. Do you understand that?
Yes.
Do you understand if you choose to take the stand, that the state attorney will have an opportunity to cross-examine you?
Yes.
And they may be able to bring up, I don't know if there is any criminal history that may be relevant under the circumstances, but if there is any, they may be able to bring that up before the jury. Do you understand?
Yes.
All right. You understand that if you choose to take the witness stand, you'll be treated the same as any other witness and subject to the same considerations of your credibility as any other witness.
Yes.
But you understand that if you choose not to testify, I will specifically tell the jury they cannot in any way hold that against you because it is a fundamental constitutional right. You understand that?
Yes.
All right. Do you feel you've had enough time to talk about this with your attorney, about this decision to testify or not testify?
I have one question.
Yes, sir. Go ahead. Yeah, would you mind? Talk to this guy. State, do you still have the sleeve for State's room? Can you give it to Corporal Lane, please? Okay. Yes, sir.
I still have updated copies of it.
Yes, sir. Thank you.
Defense as well. Thank you.
Thank you. Perfect. All right.
And right now,
Yeah, he's changed his mind. He does not wish to testify.
All right, well, I need to hear it from Mr. Terrell.
no, I'm not going to testify.
Hold on.
All right, hold on. So, Mr. Terrell, you know, Mr. Gordon is your lawyer, and he's here looking out for your best interest, and so he's going to give you what he feels is the best advice he can provide to you. But at the end of the day, this decision, like the decision of whether or not to accept the plea offer, the decision of whether or not to go to trial, the decision of whether or not to testify is solely your decision. You understand that? There were certain things we had talked about before where it's the attorney's decision on how to handle certain things. But whether or not you testify is your constitutional right, and so it's your decision. Tell me what your decision is.
If I stay quiet, I don't think it's a better idea to tell them one more time why I kept it.
Don't ask me, he's asking me.
Well, Mr. Gordon has given you his advice, and I assume he's told you what he thinks is best for you to do. But at the end of the day, it's your call. And I don't want you, and I don't want you to read. Hold on, I don't want you to read into what I'm saying as suggesting one thing or the other. I'm just making it clear it's your decision and your decision alone. You need to tell me what you'd like to do.
I assume they already know that why I went to the gas station, so I'll side with my attorney and I don't wish to.
Very well. All right. So then what we'll need to do, go ahead and have a seat, sir. What we'll need to do is you'll need to rest in front of the jury. With that being said, since Mr. Terrell is not exercising his right to testify and is instead exercising his right to remain silent, Let's go ahead and do the charge conference now, because ideally, I know it's getting close to 5 o'clock, but I'd really like to see if we can finish today. I know we're going to push a little late, but I think that would be ideal to try to finish tonight if we can. If the jurors push too late, we'll have to call it and send it, and pick up deliberations in the morning, but I'd like to try to finish tonight.
My only concern is that we did not do anything where I asked if it's okay if anybody can stay late. That's my concern.
I'll ask.
Sure.
Yep, I'll ask before closings. Right, because if we're gonna send them home, I'll send them home and we'll do closings in the morning. But if they're all okay staying late, we'll do closings, instructions. Let's try to get it done tonight, but we'll ask. All right.
I have no problem.
Everyone available? I think it's best for everybody involved if we can resolve it tonight. If we need to send them home, we will. That's fine. And as I said, if any of the jurors say no, I have to go, then we'll have to send them home. All right, so let's go ahead and go through the instructions real quick. All right, everyone ready?
Okay, yes. But don't get me wrong, I think it's in a different font.
It is, but is that going to be an issue? 3.112 is bold, and it looks like ever so slightly smaller. It doesn't bother me, but if you want it changed.
I've never had this issue. I don't think it's a big deal.
Okay, so you're okay with it?
Yes.
All right. All right, so let's go to 3.1, introduction to final instructions. Any objection from the defense?
No.
All right. 3.2, statement of charge. Any objection from the defense? 28.1, driving under the influence. Any objection?
No.
21.2, resisting officer without violence. Any objection?
No.
3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objection?
Maybe not.
3.9, weighing the evidence. You'd indicated number 6 was of some concern to you.
Yes, Your Honor. I don't think there was anything.
There wasn't?
No, I don't. Did the witness at some time make the statement that it's inconsistent? I don't think there was any of that.
I agree, but so you want number 6 removed?
Yes.
State. Any objection to removing number 6?
Yes, Your Honor, it's part of weighing the evidence. The jury is allowed to consider all of those options. If they don't apply, the jury would not use, number 6, but we figured something that they,
Your witness is the only one that testified.
Yes, Your Honor.
You want that in?
I mean, if defense counsel wants it removed,
All right, number 6 will be removed. All right, and so I'm going to go with the second version of 3.9, where we make sure we remove, obviously, the fact that the defendant has, in this case, become a witness. That paragraph will be removed.
Correct.
All right, and so we'll do 3.9A, defendant not testifying.
Correct.
3.9B, the defense has asked, defendant statements, the defense has asked that be included. Any objection from the state?
3.9, Your Honor?
3.9B, defendant statements.
No objection.
All right. 3.10, rules for deliberation. Any objection from the defense?
No.
3.11, cautionary instruction. Any objection?
No.
3.12, verdict. Any objection?
No.
3.12A, single defendant, multiple counts or inflammations. Any objection?
No.
All right, we have 2 verdict forms. One under the MM is the correct charge, resisting officer without violence. Any objection?
No, neither, no.
All right, and then I've got the verdict form for 18 CT 2900. Any objection?
No.
3.13, submitting case to jury. Any objection?
No.
And then that's it. I'll do, there's a standard instruction part of closing arguments that I intend to read. Other than that, I think we're good. All right, and the paragraph for defendant becoming a witness is, yes?
Yes, sir.
All right,
May I approve?
yes, please. All right, how long does each side want for closing arguments?
20 minutes, 30 minutes, 10 minutes, whatever there is.
State.
I would say 10 minutes
10 minutes total?
total.
Combined.
For the state.
Right, so you're gonna use some amount of 10 minutes and reserve the remainder for rebuttal?
No, Your Honor, we have 15 minutes.
All right, so like 10 and 5?
Yes, Your Honor.
All right, 15 minutes then for the defense. Very good.
Your
I'm sure you
Honor,
may want 15 minutes.
They don't have to use all of it.
Oh, I know, I'm just.
Your Honor,
They can use however much they want. Yes, ma'am.
the state will be using the demonstrative aid for closing. Do you want to set the easel up now or after the Lynette Rice?
No, set the easel up now, but leave the aids down here until you need them.
Rob?
Yes.
For the, I think, can I just take a quick break outside, just come back in?
Yes, go ahead.
State, where do you want
Just as close as possible without interrupting anyone's view.
Okay.
it? I'll give you the number.
Does that work for you?
No, Your Honor, we have it a little bit closer to the jury.
Mr. Single, why don't you put it where you want it?
Okay, thank you.
Yep. All right, we're gonna go off the record for this one, please.
Thank you, sir.
Yep. I'm not gonna touch anything.
Please don't.
back live streaming. All right, we're back on the record in the state of Florida versus Eric Shane Terrell, 18mm 2801 and 18mm 290, 18CT, excuse me, 2900. Counsel for the state and defense are back in the courtroom. Mr. Terrell is present in the courtroom. All right, are there any other matters we need to address before we bring the jurors in?
No.
All right. State, who's doing which closings?
I'm doing the closing.
Very well. All right.
Your demonstrative aids are over there.
All right. All right, are we ready to bring the jury in?
Yes.
Good.
Bravo, bring the jury in. You're on the jury.
Yes, sir.
Come on.
Jury has re-entered the courtroom. Everyone please be seated. Members of the jury, we took a few extra minutes because we wanted to sort through all of our remaining issues. And so I have a question for all of you. We didn't address this in voir dire, we normally do, but we had a few hiccups, and so it slowed our progress down. But we are in the home stretch. It is now 5:13. Let me ask this. Defense, do you wish to proceed with presenting a case at this time?
We rest, Your Honor.
Defense is resting. So we're at the point of the trial now where we're going to closing arguments and then deliberation. But I did not ask you whether or not any of you have any obligations after 5 o'clock today that you would have to deal with, or are you available to stay a little late this evening and finish tonight? And so if any of you have any obligations that you feel you must get to this evening, please let me know and I can release you and we'll finish in the morning. But if you all are acceptable with trying to finish tonight, we can do that as well. Is there anyone who has any issues at all, childcare issues, work issues, anything like that that I need to be aware of that would interfere with your ability to stay a little bit into the evening?
I don't have any issues.
All right. Is it your preference that we keep going this evening? All right. Very well. Thank you, folks. All right. And for the record, the entire jury panel did indicate yes, they would prefer to finish this evening if possible. All right. So with that being said, I'm going to read the following instructions. All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Both the state and the defendant have now rested their case. The attorneys will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen carefully and closely to their arguments. They are intended to aid you in your understanding of the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Now, Eric Shane Terrell, the defendant in this case, has been accused of the following crimes: driving under the influence of alcohol, and resisting an officer without violence. To prove the crime of driving under the influence, the state must prove the following two elements beyond a reasonable doubt. Number one, Eric Shane Terrell drove a vehicle. Number two, while driving the vehicle, Eric Shane Terrell was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. The court now instructs you that normal faculties include, but are not limited to, the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and, in general, to normally perform the many mental and physical acts of our daily lives. Impaired means diminished in some material respect. Alcoholic beverages are considered to be substances of any kind and description which contain alcohol. To prove the crime of resisting officer without violence, the state must prove the following four elements beyond a reasonable doubt as to at least one of the alleged victims named below. Number one, Eric Shane Terrell resisted, obstructed, or opposed Deputy DeSaro. Number two, at the time, Deputy DeSaro was engaged in the lawful execution of a legal duty. Number three, at the time, Deputy DeSaro was an officer. Number four, at the time, Eric Shane Terrell knew Deputy DeSaro was an officer. The court now instructs you that every Collier County Sheriff's deputy is an officer within the meaning of the law. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number two, did the witness seem to have an accurate memory? Number three, was the witness honest and straightforward in answering the attorney's questions? Number four, did the witness have some interest in how the case should be decided? Number five, does the witness's testimony agree with the other testimony and other evidence in the case? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make sure it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right. And with that, State, are you ready to proceed at this time?
Yes, Your Honor.
Please do so.
Members of the jury, first I want to thank you all for being here today. I know it's no small task, for them all day, and no small task for me, especially attorney today. So you've heard the jury instructions by Judge Brown. Stated the burden proving beyond reasonable doubt that the defendant committed the crimes of driving under the influence and resisting arrest without violence. What is reasonable doubt? Well, the definition tells us what reasonable doubt is not. Reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Those are not reasonable doubt. And such doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. It's the jury's job to decide what the reasonable basis is. What is reasonable based on all the evidence. So how do we weigh the evidence? We receive instructions on that as well. Some of the things you should consider are: did the witness seem to have an opportunity to see and know things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's question? Did the witness have some interest in how the case was decided? Does the witness's testimony agree with the other testimony and the other evidence in that case? The next step to take is to take that evidence and apply it to the law. What is the law? Well, we have checklists for that as well. And the defendant was charged with arrest or resisting arrest without violence. For the crime of resisting arrest without violence, the state must prove the following four elements beyond reasonable doubt. First, we have to prove we'll just get rid of number 3 here first. At the time, Deputy DeSar was an officer. We know that element was satisfied based on Deputy DeSar's testimony. He was employed as an officer at CCSO for 8 years and was employed at the time of the incident and was on duty that night. And he also identified the defendant. So that element is done. Let's see. The deputy element number 4, at the time, Eric Shane Terrell knew Deputy DeSar was an officer. At the time, the deputy testified he was in his marked patrol car in uniform. He turned on his siren, activated his lights, activated his spotlight, activated his loudspeaker, followed him for 3 minutes with his lights on. Deputy DeSar was clearly identified as an officer. Then let's see, element number 2. At the time, Deputy DeSar was engaged in lawful execution of illegal duty. Again, based on the testimony in the video, the officer was assigned to road patrol and witnessed the defendant drive in an impaired manner.
I'm sorry to interrupt you, sir. Mr. Gordon, may I ask you to put the public away? Sure. Thank you, sir.
Oh, you want to?
You're okay right there.
Thank you. Because that officer was attempting to conduct a lawful traffic stop, after witnessing the driver do a U-turn, hit a curb, swerve, change lanes multiple times, and then not stop after his lights were on for 3 minutes, we know Deputy DeSar was engaged in lawful legal duty. Lastly, last but not least, did Mr. Burrell, according to the testimony, number 1, Eric Shane Burrell resisted, obstructed, or opposed Deputy DeSar? According to the testimony again, and in the video, it took the defendant over 3 minutes to pull his vehicle over. The defendant had multiple opportunities to comply with the officer. The defendant chose not to. Additionally, as the testimony establishes, the defendant further resisted when the automobile was finally stopped by bracing, tensing, twisting his wrists, turning his body away, swatting away the officer's hand, and that along with passing multiple opportunities to pull over in the 3 minutes that the deputy was following him. Let's actually have it right here. The deputy put him on this map for us. There's 1, 2, 3, 4, 5 different ones that were here that he indicated were safe places that we also saw in the video for the defendant to pull over. Therefore, we've satisfied the first element as well. Eric Shane Burrell resisted, obstructed, or opposed Deputy DeSar. Next. Okay. Come to driving under the influence. And I know there was a little bit of confusion during jury selection about normal faculties. In the jury instructions, normal faculties include but are not limited to the ability to see, hear, walk, judge distances, drive an automobile, right here, make judgments, like pulling over your car when an officer can follow you for 3 minutes, and act in emergency. The elements of driving under the influence that we need to prove to establish guilt. Number 1, Eric Shane Terrell drove a vehicle. Well, the officer identified him as the driver of the vehicle. We saw him on video getting out of the vehicle. The testimony establishes that he was a driver, so we got that element out of the way. Element number 2, while driving the vehicle, Eric Shane Terrell was under the influence of alcoholic beverages to the extent his normal faculties were impaired. The video and testimony established the defendant had an odor of alcohol, bloodshot, glassy eyes when the officer or deputy approached the vehicle. We witnessed in the video an unusual driving pattern, which, as the deputy's testimony stated, started with the U-turn where he hit a curb, then drove. As the video progressed, we saw him ride the center line, switch from side to side. He was changing lanes. He again passed a number of spots. He wasn't using good judgment on where to stop.
2 minutes.
So the defendant would not pull over when the deputy attempted to conduct this traffic stop. Why would he not pull over? There's only one reason for explanation. The defendant was driving while impaired. The defendant was offered an opportunity multiple times to dispel the deputy's concerns that he was impaired by completing field sobriety, yet the defendant still refused. Wouldn't someone who's not guilty of crime want to complete the field sobriety exercise and go home? Lastly, have any of you been without a car for a day, let alone a whole year? What does that privilege mean to you? Mr. Terrell was willing to lose his driver's license for a year not to take that breath. Why? Because he knew what it would show. It would show that he was driving while impaired. Therefore, the state asks you to return a verdict of guilty on both charges. Thank you.
All right, I'm going to ask Mr. Gordon, since you commandeered the state's seat, would you please take some of the wipes and just wipe down the seat for him? Mr. Cinco, I will ask you if you wouldn't mind removing the demonstrative aids for defense counsel statement.
Yes, Your Honor.
Thank you, sir. Thank you, Mr. Gordon. Mr. Singer, did you wipe down the lectern?
Oh, my apologies, Your Honor. I know what that is.
So, folks, we are adjusting to our new COVID protocols. I appreciate your patience with us. This is all very new to us. In fact, I'm pretty sure this is the first trial that anybody in this room has done under these new protocols. So I appreciate your patience with this.
Thank you, Mayor.
Yes, sir.
I have it at 5:34. Ladies and gentlemen, the state has presented a case where their allegations are my client was driving while under the influence of alcohol. And also, furthermore, that throughout this episode, that my client resisted the arrest. And here we are, trying to figure out whether elements presented by the state meet the facts of what happened at the fatal day on December 7th, 2003. So, let me start off with where we begin, the charging document, the information. It was a DUI, which the state presented their elements. And then in the element it says that he did unlawfully drive, was in physical control of the vehicle, and was under the influence of drugs that they said they were backwards to work there. Now, one of the issues that we had in this case that I did during the cross-examination was I asked Deputy Visario, if you recollect, I asked him during the video, how many times, he could have stopped him, what have you. He could have stopped here, he could have stopped there. And then, admittedly, those places would have been possibly areas that he could have stopped. But was it reasonable? And there's a saying that I adhere to, bestowing this upon you, and it's from Judge Judy. What's reasonable is believable. And conversely, it's not reasonable, it's not believable. The position of defense, our position, as far as the driving assistance, at 3 o'clock in the morning, on December 7th, Pearl Harbor, that in that instance, where my client was driving, he was not reasonable to pull over at a cul-de-sac, or off to the side of the road, or anywhere, except what he said at the very end when I asked him, what would have been the best place? The gas station? Yes. That's what he did. That's what my client did. You saw him driving. Admittedly, he did cross over one time, meander from the left into the right lane. But throughout the whole episode, he wasn't speeding, he wasn't driving erratically, he wasn't going off and going into the ditch or what have you. You didn't see that. What we saw was normal driving. And it's the allegation, which we didn't see, was that there was a U-turn before the video came on that he made a U-turn. Nothing in that 4 minutes. 1 minute before, the light would turn on, and 3 minutes thereafter showed any indication that my client driving with anything that is normal. And the state, in their poster here, even said, I'll make it over here. Normal faculties, and I recollect asking you all during jury selection. Driving, do you think that's a normal faculty? I believe it was the gentleman there back. He said that's a skill. Absolutely correct. In the defensive position, that if you're driving and it's a skill, and it's not impaired, it's not driving erratically, it's reasonable, then it's not driving under the influence to the extent that you're now. Normal faculties are impaired. So, and also, I made during jury selection, I asked something that the state actually brought up, and I clarified it. I don't know if you read what, kissing the curb. The state's burden in this case is not to show I was kissing the curb or down. That's not what the thing is. Their standard is impairment. That's a tricky line for the hazy line, ambiguous. And in this instance, what evidence does the state provide to show that my client was impaired? It's our position that the evidence in this case does not rise to the level to the extent that my client's normal faculty. One is his driving. I submit that this case, in this particular case, there was no evidence of impairment because of the driving. Also, when he got out of the car, if you recollect, during opening statement, the state mentioned that he was dragged out of it. And when I cross-examined him, he could have opened the door. Meaning, my client opened the door. We got him by one hand. So Collier got him out. He exited the car. I understand he was having a cigarette, but nonetheless, he was still driving, and he voluntarily walked out. There was not a situation where they cracked the door open and get him out. So, understandably, when he got out, he was complying with their requests, with their orders to get out. And I'm gonna come back where the Sario said he was swaying his hand right there without resisting. I'll get back to that. But we saw the video, and nothing in that video, during in the backseat of his car, did you hear that my client was impaired? There was only slurred speech. There was none of that. You didn't hear any mention of anything that I was from alcohol or anything. Only allegations is like that Deputy Cesario, forgive me, Cesario, is that he had bloodshot eyes. In his opinion, there was emanating of alcohol. And then you hear in the video, he says, there's two other people in the car. So, and one of the things that I want to point out is during the video is the taking out. You notice that they were angry. Remember what I asked the deputy? Was that you? Remember they had their guns drawn out? Was that you? No, that was somebody else. That somebody else was angry. That somebody else is not, I'm not trying to make it a central issue in this case, but those deputies were angry. It's understandable that Deputy Cesario was angry because despite the 3 minutes before, in his standard, in his profession, it's expected that he has to, when somebody puts on the light, he's expecting to do it all. It didn't happen. And it was reasonable under circumstances. It's dark, 3 a.m. He's trying to pull over at a safe location. And that's exactly what he did. So, now, then you get, and also, one of the issues is, if you recollect, I asked Deputy Cesario about trying to do the field sobriety exercises at the station. He said it's already too late. It's already too late. And also, according to him, that my client is used. Okay? And the reason why I bring this up is, when my client was taken out, handcuffed, and placed in the back of the seat of the car.
2 minutes, Mr. Ward.
How many?
Oh, 2 minutes.
10 minutes?
2. Oh, I'm sorry. You have both sides. 5 minutes. I apologize. 5. I'm sorry. Sorry to
Yes, I saw 5:34.
Yes, sir. I'm sorry. I forgot you have the full time that the state has combined. Please continue. I apologize for you all.
5 minutes.
5 minutes, sir.
5 minutes. Great. Anyway, when he got out of the car and he was placed in the back seat, it's reasonable to expect that he's under arrest. And at that time, when he's asked to blow, he refused. He's under arrest. Why would he help the state deputy to provide more evidence? He's under arrest. They've already concluded that he is under the influence to the extent of his criminal faculty services, and therefore he's not saying guilty, right? But that's what their allegations are. So his refusal is reasonable. Now, I have 5 minutes and I don't want to linger on this issue, but I want to get back to the issue of the resistance. Charging document in this particular case, it says, December 7th, 2018, did unlawfully resist, obstruct, or oppose deputy Brian Cesario of Flycom Ship in the execution of a legal process, which is not an issue, in order to lawful execution of a legal duty. Okay? By the way, just to make sure you understand, legal process is not the issue in this particular process. Sure. But it's the legal execution of legal duty. And it's their position, in their charging document, in their complaint, to wit, conducting a lawful traffic stop, not when he's handcuffed. I.e., when he's being drugged, when my client is driving, when he turns on the light, that's where the resisting charge comes from. And now they're saying, Deputy Cesario is saying, wait a minute, The resisting came during, when he was behind me, or trying to handcuff him, he did some shake or something to that effect. That's when he resisted. I asked him, point blank, black and white. So, it's our position that the state absolutely has not met any the burden as specified for the resisting of an officer without violence. Now, also, I just want to point out that when they got to the station, it's the point that is that he was asking him to blow. He didn't blow. And that should not be held against him. And by the way, the last thing I want to say is my client decided not to take a stand. There's many reasons why someone doesn't take a stand. Some people are able to speak in public and some are not. So please, do not hold the silence against him in this case. And it's our position that the state has not met any of the burdens beyond a reasonable doubt in both DUI and the resistance. Now, I expect you to find my client not good. Thank you very much.
Thank you, Mr. Wilson. Mr. I'm sorry, I'm gonna have to ask you to go ahead and. Thanks. State rebuttal.
Council that a reasonable place to stop is the gas station. 1, 2, 3, 4, 5. Before arriving at the gas station was not a reasonable place to pull over. How many times have you driven down the road and seen people pull over on the side of the road? Pull over in the turning lane. You saw the video. You've got 2 turning lanes from Collier Boulevard to City Gate Drive. So the defendant took 2 open wide turning lanes. No other cars on the road at 3 a.m. But that's an unreasonable place to pull over. And we saw this spot where the deputy also pointed out with the spotlight. A little case cement over to the side of the road where you can pull over. But council said that's not a reasonable place to pull over. The defendant had multiple opportunities to pull over, and he chose not to. He chose to ignore the siren, he chose to ignore the light, he chose to ignore the spotlight, he chose to ignore the PA system that verbally ordered him to pull over. So we finally made that U-turn back into the gas station. Every time he passed an opportunity to safely pull over, he was resisting. He obstructed the officer's traffic. The deputy Pizarro was on the stand and he told me, yes, he obstructed my traffic stop by not immediately pulling over. He also said it typically takes about 10 to 15 seconds for people to pull over. The defendant took more than 3 minutes. Handcuffing. Deputy Pizarro also explained to you how the defendant resisted when they had to physically remove him out of the vehicle. So he was twisting his arm, stiffening out his hand out, making it more difficult for him to be handcuffed. That is resistance.
Like when child is taking away your can or the shoe, they don't want that shoe on. And we also saw on the video the defendant hurt his body multiple times, making it harder for Deputy Desaro to handle them. DUI. Co-counsel, Mr. Diesel went over starting up. The defense counsel said, we saw in the video normal drive. Well, is it normal to make a wide U-turn and drive onto and over concrete curb? That's not normal. Is it normal to change lanes multiple times at 3 in the morning when there's no other traffic obstructing you? That's not normal. And we also saw the defendant driving on both lanes multiple times. First, when he makes the turn into City Gate from Collier Boulevard, not stopping at the red flashing arrow, but you have to come to complete stop, which is what Deputy Desaro testified to. Makes that turn, and he is driving on both lanes. Makes another turn, and is driving on both lanes before he eventually chooses one lane. And you can watch that video over and over again as many times as you want. That's not normal driving. The defendant's lack of responding quickly goes to his impaired faculty. Those impaired faculties that will prevent him from responding to emergency, from making decisions, from judging distance, because we can clearly see on the video that he drove quite a bit before he actually moved. His faculties were impaired. We have an odor of alcohol, we have bloodshot eyes as well. And we have the defendant refusing field sobriety exercises at a run. Deputy Desaro gave multiple opportunities to perform field sobriety exercises. The defendant said, at minute 25, I cannot do that. No reason I should do that because I was not drinking.
You're at parking minutes.
Okay.
You've just been parking minutes. Yes, ma'am.
The state is just going to request that you please become a verdict of guilty as to both charges.
Thank you. Members of the jury, there are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. If you return a verdict of guilty, it should be for the offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to each crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you, and I will show you them in just a moment. A separate crime is charged in each information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect the verdict as to the other crime charged. And so there are two verdict forms, and they are here. And these will be handed to you along with all the instructions I've read to you. They will be handed to you as well for you to review in the jury room. They are similar in that they have what we call the style of the case on top. That's the name along with the case number. It says verdict, and then it'll say count one. The one I'm showing to you now is the driving under the influence case. The other one says resisting officer without violence. It says, we, the jury, find as follows as to the defendant in this case, check only one, please. The defendant is guilty of driving under the influence, or you can mark the defendant is not guilty. And then the other verdict form is very similar. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seat, where they will be guarded by our bailiffs while you deliberate. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note to the bailiff signed by the foreperson. If you have questions, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, there was one item received into evidence as an exhibit. That was the video in this case. You may examine that exhibit if you think it will help you in your deliberations. If you do wish to view the video, let us know through a note. If you have to come back in the courtroom, we can play it for you in here, okay? In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Now, 2 more quick things before you are allowed to retire for your deliberation. Number 1, for those of you who are retiring to the jury room, which as you notice is actually a courtroom. Our jury rooms are small. We didn't feel comfortable putting a whole bunch of people in a small room for a lengthy period of time, and so we're using the courtroom, which is obviously much bigger and allow you to communicate with one another, but still allow for social distancing. So I will ask that those of you who go to retire to the deliberations continue to maintain social distancing while you are deliberating. The other thing is Sioke. I want to thank you very much for your time and attention today. You are an alternate juror. I don't want you to think we played a trick on you by not telling you in advance. The reason we don't tell people in advance is because some folks wouldn't pay attention if we did. And our very last trial, we did meet our alternate juror on the first day. Something came up, and one of the regular jurors had to leave, and so they were pressed into service. So you will not be able to deliberate with the rest of the jurors. I'll ask you to remain while the remainder of the jury leaves to deliberate this time. State defense, are there any other matters that need to be addressed before the jurors are permitted to deliberate?
No.
All right, all rise for the jury.
All rise for the jury.
Folks, you need your notes, and you leave the notes on the chat.
You can bring everything back. I'll get them from you at the
The standard instruction does say to leave them on the chair. You were listening. Thank you, sir.
Yeah.
But we do it a little bit differently. They will collect them from you.
Follow the ballot.
No, ma'am, you wait here.
Your notes except for you. You have to stay where you're at.
Okay.
Yep, you're good where you are. Man.
Okay. If you have your notes, take them. If you don't have any notes, you can use. It's up to you. Thank you, sir.
All right, ma'am. What I have here is a certificate of jury service. And I'll be frank with you, while we traditionally just give these out, this doesn't come anywhere near to expressing my appreciation for you being here today. I told the folks upstairs who were waiting for their turn, just in case we needed more folks during jury selection. This is the first jury trial that I've been able to have since last February. And without a jury, a lot of things just simply can't function. So your presence in this building has allowed justice to move forward. And from the bottom of my heart, I do wish to thank you. You're welcome to stick around. If you'd like to see how this turns out, you can watch it on YouTube if you want. Otherwise, you're free to go. Go ahead to see fit. Thank you so much for your service to this court, to these folks here, and to the citizens of the 20th Circuit. Thank you, ma'am. Everyone, please be seated. All right. Are there any other matters either side would like to address before we recess? Ms. Gordon? No, not a good idea. All right. Okay, that's fine. All right, state anything else? All right, then we'll go off the record. If you're going to leave the courtroom, give our clerk your cell phone number so we can call you. All right, we are back on the record in the state of Florida versus Eric Shane Terrell, 18MM 2801, 18CT 2900. We have a request from the jurors to rewatch the video. Is there any way we can unplug it and move it closer to the jurors so they can really see it?
Yes, Your Honor, as long as there's a plug close enough.
Because we've all seen it now, so I just want the jurors to see it.
Your Honor, are we aware if you want to see the video in its entirety or the portions are?
I don't know. So what I'm going to tell them what we're going to do is that we're going to start playing it. Mr. Cinco, well, pray either of you, just be nearby and tell jurors they can let you know if and when they want to stop it. I'm going to make the jurors request part of the court file. Give you a chance to clean up a little bit. Are they assembling the jurors?
Would you like me to have them lined up there?
Yes, please.
Two Bravo, bring the jurors back and line them up in the back hall.
So, folks, here's something that's very important. Mr. Terrell, because they're in deliberations right now, I have to order everybody to remain strictly silent while the jurors are watching this evidence. Because if they're in deliberations, we can have no communications about anything.
Yes, sir.
With the jurors present, okay? It's very important that we don't say anything.
Understood.
All right, thank you, sir.
You're on the jury.
All right? Jury has re-entered the courtroom. Everyone please be seated. All right. Folks, I got a request that you all wanted to watch the video again.
Yes.
So here's what we're going to do. I'm going to ask one of our state attorneys to, there you go. We figure if we move it a little bit closer, that might help you all. I'm going to have one of my state attorneys stand by the computer. We're going to start from the very beginning. At any point, if you wish us to stop it, just tell us to stop it. Or you can watch the whole thing through. Do not discuss anything right now in front of us. Any discussions have to be done in the jury room. You all understand?
Yes.
Very good. State. Was the TV? Never mind. It is.
He's got a blown tire, and you have to stop eventually. He's going into City Gate gas station. Maybe. We're still wrong. Pull it over now. He's just not stopping. We're going into the shop in 3 years.
Turn the car off now. Get your dog before you get shot. Grab your dog before you get your dog back. You understand English? Shut your car off and put your hands on the steering wheel. Everybody hands up now. I don't want to go down. Shut your mouth and listen to what I'm saying. Put your hands on the car and shut up. Get out of the car. Get out of the car. Put the stick right down. What's your deal? I'm not trying to go down. You want to go the wrong way. Stop moving. Stop. No, I'm not. I was trying to turn it over. I saw you crash your car. No, I don't have power steering. That's what it is. No, I don't have power steering. That's right. You have any guns, weapons, knives, anything, you know that? Sharp, poker, shaping? No, I don't. No, actually, I was using that in my work shirt and all that. Yeah. No, I know, No, I'm not. I was giving them a ride home, that's it. No, don't resist. Next time you do it, give me a big hug. No, I don't do that. Let's go. No, I'm not. Sir, I was trying to go the right way before I went the wrong way. No, I was parking lot, it's all right. I was trying to. All you gotta do is pull over. I don't care where you pull over. You just gotta pull over. I was trying to respect you. I didn't want to go on the camera in the wrong way. Where's your wallet? Okay. You're up. Where? Yes, sir. ERC? Yes, sir. Your middle name? Shane? Last name? Gerald, spell like Gerald, T-E-R-R-E-L-L. Date of birth? 06/09/1983. 06/09/1983. Get the gas station pull over.
Well, I mean, I seen you guys in there, I wasn't trying to run that time.
That's 2029, maybe. Last of Terrell, Echo Romeo, Echo Lima, first is Eric, Echo Romeo, India Charlie, Million S Sierra. They were 6983 right now. I was trying to get my report done, and I seen him do a U-turn. He does a U-turn right in front of the Quality Inn. And he did a U-turn right in front of the Quality Inn and went right over the curb. And I just boom, and kept going, kept going. Yeah, I saw you guys all were like, nobody was gonna punch it. Yeah, I was thinking you guys would have like sticks in your ear.
All of that turned into 31 was only the shortest one, because I was at 25 with my chopsticks already. This is all of the female stuff. Yes.
Okay, yeah, very.
That's not her, is it? I just ran it.
Do you have anything on her?
No, she didn't have anything on it. I haven't asked her any questions, I don't know what her side of it is, whether or not I talk to her.
Yeah, if you want. Last night, hospital, versus. You check yourself. No. Which one? Which side? Yeah. Hey, you got the, where you go? Kitty. Kitty. Come on. Kitty.
okay, talk to the evidence bags? Are they in trouble or?
Multiple people. Yeah, it's like that. Well, because I saw him U-turn in front of Quality and I know which detective, you seem like he did a U-turn in front of Quality and hit the curb. So I thought he popped a tire.
I can see how driving would look like that.
It was flat. He hit it hard. He just started to cut it off. I got him for at least signal one, but I can go again out of here until I find out what else to do.
Yeah, we'll kind of on the go, go with all.
So transport him down there. And then they're gonna have to check the station too. It's complicated. Good.
I'm valid in Illinois.
You can't get here.
But I have, do you need that license, sir? I'm not trying to, I'm trying to make you.
Check for here and Torello in Illinois. Is it your dog?
Yeah, I have him too.
Well,
my roommate passed away, I got him when my roommate passed away.
seems like a good dog. Yeah. Seems like he's calmed down. Alright. Eric, you have the right to remain silent. Anything you say can will be used against you in the court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you for any questioning. If you decide to answer questions now without a lawyer present, you'll still have the right to stop answering at any time until you talk to a lawyer. Do you understand each of these rights that I've explained them to you?
What have I been arrested for?
I have told you if you're arrested yet. I have to read you these. These are your Miranda rights. Do you understand those?
I understand that, sir.
All right. And with those rights in mind, you wish to talk to me now?
Embarrassment, that,
In regards to the incident of why I stopped this vehicle.
and why was that stopped?
Because you're acting erratically, you drove up on the curb when you did a U-turn in front of the Quality Inn. Okay, then you failed to stop for, I'd say, the top.
Yeah, no, I understand that, I have reason for that. It's because I didn't want to go down the wrong way and I wanted to pull over in a proper place.
And you do with your level of intoxication.
No, no, I haven't drinking at all.
Do you wish to talk to me?
About what?
About this? I just told you.
Well,
Yes or no? Yes or no? Yes or no?
Yes, I have a question. What was the initial stop, reason for the stop?
You're erratic driving and dropped over a curb.
Okay, when I did the U-turn, it was a legal U-turn, and as I
You went
went
over a curb.
I don't have power steering.
You went over.
All right, let's go on the record. Thank you. All right, we're back on the record at 18 CT 2900, 18 MM 2801. Counsel for the state and the defense are present, and the defendant, Mr. Terrell, is back in the courtroom. I understand we have a verdict. Is everyone ready for the jury to come in?
Yes. Before Raymond.
All rise for the jury.
Your Honor, the jury.
All right, the jury has re-entered the courtroom. Everyone can please be seated. All right, members of the jury, I understand that you have rendered a verdict. Is that correct? And who is our foreperson? All right, ma'am, do we have a verdict on both forms?
Yes.
Very well. Could you please hand them to my bailiff? I'll ask the defense to please remain standing. Thank you. And that's Madam Clerk to please publish the verdict.
In the County Court of the 20th Judicial Circuit in and for Collier County, Florida, criminal action. State of Florida versus Eric Shane Terrell, case number 18 CT 2900. Verdict. Count 1, driving under the influence. We, the jury, find as follows. As to the defendant in this case, the defendant is guilty of driving under the influence. So say we all, signed by Susan Guarino and dated February 11, 2021. In the Collier County Court of the 20th Judicial Circuit in and Collier County, Florida, criminal action, State of Florida versus Eric Shane Terrell, case number 18 MM 2801. Verdict. Count 1, resisting officer without violence. We, the jury, find as follows. As to the defendant in this case, the defendant is not guilty. So say we all, signed by 4 persons, Susan Guarino, and dated February 11, 2021.
Thank you. Defense, please be seated. Would either side like the jury to be polled? All right. Members of the jury, your service has come to an end. I always thank the jurors for their service, but particularly this time, I want to say thank you. I told your colleague, the alternate, before she left, this is the first jury I've had since February of last year. And so we can't function in this courthouse without jurors. The jury is the bedrock of our entire judicial system in this country. Cases get resolved when people like yourselves are willing to come forth and do your duty as citizens. and you've provided great service today. And I want to thank you truly, all of you, for your time and attention and your service to us in this courtroom, to the defendant, to the state, and to your fellow citizens. You really have done a great service today, and I want to thank every one of you so much. With that, you are free to go. These gentlemen will escort you out. Thank you again. All rise for the jury. Everyone please be seated. All right, so in 18MM2801, Mr. Terrell, the jury having found you not guilty, you'll be discharged for that offense immediately. So then we turn to 18CT2900. Mr. Gordon, is there any reason why I cannot proceed to sentencing at this time?
No.
State? All right. Would either side like to present any argument or any presentation? State. All right. Mr. Terrell, given that this was amended down to a first offense DUI, you've already served a maximum jail sentence. So therefore, your sentence will be imposed as follows. State, I did take a more careful look at the statute. Turns out there are certain conditions that per statute, per 316.193, must be imposed as conditions of probation. Otherwise, I would be inclined to not do it, but I have to. So, Mr. Terrell, you'll be adjudicated guilty because that is required for a DUI. I will sentence you to time served. 12 months probation. Special conditions of probation. Well, no, I can do that. All right, 12 months probation. Special conditions of probation are as follows. You must attend and successfully complete a DUI school tort rate phase. You're subject to random testing and your analysis at your own expense. You must attend a substance abuse evaluation and follow any recommended treatment. You may not possess or consume any alcoholic beverages, no entering bars, taverns, saloons, pubs, lounges, or package stores, no alcoholic beverages in your residence. 10-day vehicle immobilization. You must perform 50 hours of community service. There's a $500 minimum fine. Applicable court costs, I believe, are $388. Does that include, no, $50 cost of prosecution. There is a mandatory, was there a public offender application fee that's owed?
There is a $50 application fee on each case.
Well, no, on the one that he was found not guilty on, he doesn't have to pay that.
Well, if the application fee, when he applied.
If he was found not guilty on both, he would owe nothing. So the application fee only applies to one case.
Okay. So that would be the
All right, $50 application fee. Mr. Gorgian, as far as being appointed off the wheel goes, normally I would assess a public offender or regional counsel fee. Is that applicable in this case with off the wheel, or are you just paid by JAC?
I'll pay by case.
All right.
I've been asked to add, I know judges are not doing it, I don't expect you to do it, but I know Judge Mason absolutely vehemently denied any cost by JAC to be imposed on defendant's probation.
Here's what I'm gonna do. I'll reserve jurisdiction, and if you want to seek it, feel free to do so, and we can have a hearing on it. Because Mr. Terrell, you would have an opportunity to object to that if you wish. So I'll reserve jurisdiction on costs to be paid to JAC. There's going to be a 6-month driver's license suspension, which is also mandatory by statute. Did I miss anything as far as mandatory DUI penalties? Minimum.
That's the DUI means.
Yes, they are. The minimum mandatory penalties. Is there anything else that I've missed?
victim impact panel?
What's that?
The victim.
The victim impact panel. Yes, ma'am. State, any other DUI minutes that I've missed? I did do that. I did. I said time served.
Right, which means he gets released during a regular meeting.
Right.
Credit for time served means he has to go back so they can credit his time and book him out from there.
I'm confused.
If he was to get time served, he would be walking out of this courtroom right now without having to go back.
I understand. All right. So the sentence would be 1 day in the county jail, credit for all time served. I'm just doing that, sir, so you can be properly processed back to the jail. You can obtain any personal items that's in property. It's for your benefit. So you can be properly processed and get anything you might have back. You'll still be released right away.
Today, tonight.
Yes, you're done. Your sentence is, your jail sentence is complete. You will not serve any more jail time. I just want to make sure that you're properly processed so you're not left in a situation where you are unable to obtain your personal items or things like that when you're first worked into the jail, okay?
Okay, I have a question about the license. I'm sure you.
I'll explain it to you.
I mean, it's already been suspended.
I'll explain it to you.
It's okay, Mr. Gordon. If he has a question, I'll answer
All right,
it.
that's fine. He's got it. I'll figure out.
No, that's not an issue. I'm just saying that the license, I have to check it. If it was suspended, it's already been 6 months.
All right. All I can do is impose a 6-month suspension as part of the conviction. I have no idea how that might affect any other, any out-of-state license.
Well, it would be illegal for them to do it twice, right?
No, there can be multiple suspensions for a driving record.
For one, I'm saying for the same.
Yes, there can be multiple bases for suspending your driver's license. Yep. So if it was previously suspended for something else, it can still be suspended for this, and both suspensions will be in effect until they can be rectified.
For the same thing, not something else, for the same ticket.
That's right. There is an administrative suspension for the refusal, and now there is a court-ordered suspension for the conviction. Those are two separate suspensions, but they are both lawful and imposed. All right? Are there any other mandatory minimum penalties that I failed to impose?
That's what I know of. I haven't.
Not my honor.
All right. Actually,
Is there a victim impact time class or that's some kind of a trauma center?
let me ask a quick question to you, Mr. Gordon. I want to make sure that this is, because I want to be very fair to Mr. Terrell. One of the state's concerns was the original imposition of conditions of probation on the DUI, because Mr. Terrell's already served the maximum jail sentence for this offense. If I only sentence him to 1 day in jail, does he still, would you agree, he still gets credit? Should there be a VOP, does he not get credit for any time he had served on this already? Or does he need the full sentence of 180 days jail in order to obtain that credit upon VOP?
Well, no, my understanding of the case is that if you sentence him to 1 day jail time and the maximum imposed is 6 months in jail, I would argue that at that point, it's just like those, where those felony cases, the trafficking cases, where it's been going around since 2014, where the people have already sat their sentence out, the felony cases, for 5 years, 3 years, or whatever it is.
I just want to make sure that should a VOP come around, that he's entitled to all credit that he has served on this case.
Correct, that's what I would be arguing. It's kind of like that sentence, when the sentence has already been imposed, he's done the jail time.
He has.
I don't think he could do any more than that.
I don't think so, but how can we make sure the judgment and sentence properly reflects that? And so Mr. Terrell is not put in an unfair and illegal position should a VOP come around.
Well, the problem is, I don't think, it's kind of like the situation with the second degree misdemeanors, where maximum penalty is 2 months in jail and 6 months maximum, whatever.
Why don't we do this? Why don't we do this? I'd like to have the judgment accurately reflect the amount of credit that's already been served. Let's put that on the judgment. And that way, if a VOP comes, there'll be a record in the court file of how much credit he has already served.
But if you're placing him on probation, would it be kind of futile for him to actually report because he can't sit in jail?
I'm not going to tell him to violate his probation on purpose just because I can't impose additional jail time. However, Mr. Terrell, you can be held in jail pending a VOP. So I wouldn't recommend that you purposely violate your probation. You understand?
Comes with a mandatory, what, 60 days or something? 30 days?
What I'm saying is, sir, if you willfully, knowingly, willfully, and substantially violate your probation, a warrant can be issued for your arrest.
I was just wondering
If it is served upon you, you could end up sitting in jail waiting for the resolution of your violation of probation. So I would not recommend that you purposefully violate your probation.
Okay,
Understand?
I understood that in that regards to that. I was just wondering what is the repercussions, like worst case scenario, should that happen? Because
Your
I don't know
lawyer-
if it's gonna happen down the line.
Your lawyer can explain it to you, but do not brush off probation thinking that there cannot be any further sanctions.
Understood,
I just want to make sure we're clear about that. How do we calculate the credit? He was taken in on the warrant.
I have one more question. I apologize. I might not want to serve probation in this state because I'm homeless. I might want to go to another state.
State, do you have any objection to mail-in probation?
Your Honor, the state would object to mail-in probation. My understanding, however, is that once he reports to probation, he can discuss transferring probation to whatever state he is thinking of moving to.
I'm going to allow mail-in probation.
You are?
Mail-in probation first, but you do need to report to probation tomorrow.
Yes, sir.
All right, you need to come back to this courthouse, first floor, go to county probation and report that. He's report in person the first time. All right, you have to give them a current address. And make sure they know where to find you.
I will.
All right. So let me see. When was Mr. Terrell? Let's just do this. 180 days jail credit. Right?
Credit for all time.
Well, it's credit for all time served, but let's put on the judgment 180 days credit.
Okay,
Because that is the maximum sentence. It may be more than that, but at least he will get all of that should the VOP come around.
Your Honor, do we know that he's done it for 80 days already?
Well, I thought that was the issue that everyone agreed to before.
I did a roll over that.
Let's double check. The defendant was arrested on August 15th. I've got a date calculator. Today is exactly 180 days from August 15th, literally on the dot.
Okay.
I did August 15th, 2020 is the date that you were arrested on the warrant, sir. Added 180 days. Result Thursday, February 11th, 2021. We are exactly 180 days on the money. So let's put that on the judgment sentence at 180 days credit.
So 1 day with 180 credit.
180 days credit. And that way, sir, should you find, I'm encouraging you not to find yourself back in front of me. But if you do, there won't be any question that you have already served the maximum jail sentence on this offense, all right?
Yes.
What are they saying?
183 days credit according to the judge.
You want me to change it to 183?
Let's say 183, if that's what the jail is saying. Did you serve a couple of days when you were first arrested for this offense?
True.
2. There you go. There you go. That's what you get 3 credits.
I did the math the other night, and I was working math 7 months, but I could be wrong.
I didn't do the math myself. The computer did the math. All right. Is there anything else we need to address? You're going to show it to me? All right. One moment. Let me just confirm the JNS is correct. Thank you, sir.
Welcome.
I'm ready. All right. $380.
Yeah, just, I'm sorry,
Yes.
Just for your information, I have the state of Sloan versus state, 10 Southern 3rd, 686. According to the case law, this is what it says.
Okay.
It was an assault case. It says, in essence, it says, trial court placed Sloan on probation for 6 months with the condition that he resides 60 days in jail. Such a sentence is permissible.
Right. Right. Okay. So.
So in case there's an issue of ineffective or something that I misunderstood.
No. No, this is.
I understand what I'm saying. Yeah. I'm just trying to make a record to make sure if he's gonna come back and say, I didn't do my job, I just know this particular case right off my head, that's what it says.
I understand. All right. So $500 fine, 380 court costs, prosecution, the application fee. And then let's scroll down, please, for the terms. There we go. Oh, need it back. There it goes.
Would you like me to forward this case law to your JA?
No. All right. Okay, this is correct.
Okay, he's gonna serve 180 days, and as a condition of his probation, he does 180 days for jail.
He's serving, the sentence is 1 day jail, but the judgment is reflecting 183 days credit.
Okay.
So that it's going to be on the judgment and sentence that he has full credit for all the jail time that's been served.
Okay. I'll explain to him what it is.
All right. All right. Mr. Terrell, good luck to you. Stay out of trouble.
I'll do my best. I appreciate you.
Good luck to you, sir. Take care, all right?
Have a blessed one. Take care. Thank you.
All right. Anything further before the court? We are adjourned. Don't tell Bill that I pressed the button. Good job, everybody. Go home. Get a stiff drink, call it a night. Thank you, everybody.
Can I talk this?
Thank you, George.